welcome you all who came to Sunio for attending the IOI Europe Conference, Ombudsman Reloaded, Mandate and Operational Framework in a Postmodern Era. We would also like to particularly thank all those participating online from different European countries and various areas of Greece. This conference is one of the actions under the project Greek Ombudsman Actions for Strengthening Good Governance, Accountability and Combating Maladministration in the public sector. The project is co-funded by EEA Grants 2014-2021. The EEA grants represent the contribution of Iceland, Liechtenstein and Norway towards a green, competitive and inclusive Europe. We have the great honor of inviting the Speaker of the Hellenic Parliament, Mr. Tassoulas, to open the conference and address a welcome to the plenary.
Εκλεκτοί προσκεκλημένοι, με ιδιαίτερη τιμή βρίσκομαι εδώ για να κηρύξω την έναρξη των εργασιών του συνεδρίου του Ευρωπαϊκού Τμήματος των Συνηγόρων του Πολίτη με ένα κρίσιμο θέμα στην ατζέντα του, που είναι ο ρόλος και η αποστολή του θεσμού αυτού, του πολύτιμου αυτού θεσμού για τα φιλελεύθερα καθεστώτα, εν ώψη της λεγόμενης μεταμοντέρνας εποχής. Δεν ξέρω εάν θα δικαιωθεί ο όρος μεταμοντέρνα εποχή για την περίοδο που περνάμε. Θα μου επιτρέψετε, μια και βρισκόμαστε στο Σούνιο και χθες, από ό,τι ξέρω, απολαύσατε τη θέα του φωταγωγημένου ναού του Ποσειδώνα, να σας πάω σε μια εποχή που δεν είναι μοντέρνα, που είναι κλασική. Και να σας πω ότι βρίσκεστε στη χώρα και βρίσκεστε σε μια περιοχή όπου η αξίωση για ισότητα και δικαιοσύνη υμνήθηκε από τον πολιτικό εκείνο που κυβέρνησε την Αθήνα στην πιο ακμαία περίοδό της, από τον Περικλή, αυτόν που έχτισε για δεύτερη φορά του ναό του Ποσειδώνα μετά την πρώτη καταστροφή που επέφεραν οι Πέρσες. Υμνήθηκε λοιπόν αυτό που και ο συνήγορος του πολίτη σήμερα στη μεταμοντέρνα εποχή επιδιώκει. Υμνήθηκε η δικαιοσύνη, η ισότητα και η ελευθερία στον περίφημο επιτάφιο λόγο του. Και συγκρατώ 3 λέξεις από εκείνο τον ύμνο της Δημοκρατίας που εκφωνήθηκε το 430 π.Χ. γιατί είπε ο Περικλής πως η τήρηση των νόμων δεν οφείλεται στον φόβο της τιμωρίας, αλλά στο σεβασμό προς τους νόμους και στην ντροπή που προκαλεί για κάθε πολίτη να ξέρουν οι άλλοι ότι είναι παραβάτης. Ο σεβασμός στους νόμους και η ντροπή για τον παραβάτη δεν πηγάζουν από νομικά κείμενα. Πηγάζουν από ηθικές προσταγές πηγάζουν από την παιδεία, πηγάζουν από τον πολιτισμό. Κυρίες και κύριοι, πριν λίγες μέρες, ο πρόεδρος του Ευρωπαϊκού Τμήματος των Συνηγόρων του Πολίτη, ο κύριος Ποτάκης, ο Έλλην συνήγορος του πολίτη, παρουσίασε στο Κοινοβούλιο της Ελλάδος, όπως γίνεται κάθε χρόνο, την ετήσια έκθεση για το 2021. Και αυτή η ετήσια έκθεση για το 2021, ένα δύσκολο χρόνο, ακούστηκε από το Ελληνικό Κοινοβούλιο με ιδιαίτερη προσοχή και το Ελληνικό Κοινοβούλιο θα αξιοποιήσει σίγουρα όχι μόνο την εμπειρία του συνήγορου του πολίτη, αλλά και τις προτάσεις του. Και θέλω να ξέρετε ότι ο συνήγορος του πολίτη στην Ελλάδα, που συμπληρώνει σύντομα 1/4, έτσι είναι, αιώνος ζωής, γίνεται σεβαστός από τη διοίκηση και από το νομοθετικό σώμα, όχι τόσο γιατί μας το επιβάλλει ο νόμος ή ο φόβος μιας τιμωρίας για την διοίκηση όταν διαπράττει λάθη ή παρανομίες, όσο γιατί το κύρος που έχει ο συνήγορος του πολίτη δημιουργεί σεβασμό στις υποδείξεις του και ντροπή για να μην τηρεί κανείς τις υποδείξεις του. Πάμε δηλαδή αιώνες πίσω και διαπιστώνουμε ότι κατά βάθος το δικό σας γόητρο οφείλεται στον πολιτισμό μας και όχι στον καταναγκασμό μας. Θα μου πείτε ότι αυτό θυμίζει την ουτοπία του Τόμας Μορ, ένα βιβλίο που σημείωσε πάρα πολλές εκδόσεις όταν βγήκε πριν αρκετούς αιώνες στην Ευρώπη και περιγράφει με την λέξη ουτοπία το ιδανικό κράτος. Είμαι όμως βέβαιος ότι με τη βοήθεια πολύτιμων θεσμών, όπως αυτό που εκπροσωπείτε με τόση επιτυχία στις χώρες σας, η ουτοπία μπορεί σιγά σιγά να πλησιαστεί και να γίνεται κάθε μέρα ολοένα και πιο πραγματική. Γιορτάσαμε πέρσι, κυρίες και κύριοι, τα 200 χρόνια από την Επανάσταση των Ελλήνων κατά της Οθωμανικής Αυτοκρατορίας, μια επανάσταση η οποία οδήγησε στην ίδρυση του νεοελληνικού κράτους. Και για να δείτε πόσο οι ρίζες του δικού μας πολιτεύματος είναι κοντά στους εμπνευστές του θεσμού που εκπροσωπείτε και ο οποίος ξεκίνησε σε υπερβόρειες χώρες, στη Σκανδιναβία, θα σας πω ότι το πρώτο πράγμα που οι Έλληνες ανακοίνωσαν όταν ξεκίνησαν την επανάστασή τους κατά των Οθωμανών, το πρώτο πράγμα δηλαδή που ανακοίνωσε ένας λαός που ήταν 4 αιώνες σκλαβωμένος στην επίδαυρο της Πελοποννήσου, όταν έφτιαξε το πρώτο του σύνταγμα στις 15 Ιανουαρίου του 1822, τι ήταν? Ήταν η περιγραφή της αποστολής του συνήγορου του πολίτη. Διακήρυξε ο επαναστατημένος ελληνικός λαός το 1822 ότι σκοπός μας είναι η ανάκτηση, να ξανακερδίσουμε, γιατί το είχαμε παλιότερα, η ανάκτηση της ελευθερίας, της τιμής, από θεσμούς σαν των δικών σας. Και όταν ο πολίτης δικαιώνεται από τη δική σας παρέμβαση, τότε δικαιώνεται ο πολιτισμός της Δύσης, δικαιώνεται η φιλελεύθερη ιδέα, δικαιώνεται η αξία του ανθρώπου και δικαιώνεται και η προσπάθεια που γίνεται παγκοσμίως να εξαπλωθεί αυτή η ιδέα. Κλείνω αυτή την παρέμβαση λέγοντας ότι ζούμε σε καιρούς επικίνδυνους, όπου αρχαϊκά προβλήματα μας βασανίζουν και όχι μεταμοντέρνα. Ο πόλεμος για τη δική μας γενιά δεν είναι μεταμοντέρνος, είναι αρχαϊκός. Έρχεται από δεκαετίες πίσω για να επιβάλλει μια αρχαϊκή αντίληψη επίλυσης των διαφορών, μια βάρβαρη αντίληψη επίλυσης των διαφορών. Και δεν φτάνει αυτό, μας εμποδίζει να ασχοληθούμε με το υπαριθμόν ένα πρόβλημα. Το πρόβλημα με τη γη και τον αέρα, η τιμωρία μας θα είναι πολύ αυστηρή. Και αυτός ο πόλεμος μας αφαιρεί, μας απομακρύνει από το πρώτο πρόβλημα, που είναι η προστασία του περιβάλλοντος, που πρέπει να αντιμετωπίσουμε. Γιατί τα ανθρώπινα δικαιώματα, γιατί το δικαίωμα του πολίτη, το κράτος να τον σέβεται, αφορούν πολίτες οι οποίοι είναι στη ζωή. Και αν τη ζωή δεν την εξασφαλίσει ένα υγιεινό περιβάλλον, όλα αυτά θα είναι σε λίγο δευτερεύοντα. Καλωσορίζω λοιπόν τους εκπροσώπους ενός θεσμού που αντικατοπτρίζει ό,τι πιο ηθικό και ό,τι πιο πολιτισμένο επεδίωξε ο άνθρωπος πάνω σε αυτή τη γη. Τη δικαιοσύνη και την ισότητα. Και σας καλωσορίζω εδώ, στη γη της Αττικής, στη γη της Ελλάδος, η οποία σε κλασικούς και όχι μοντέρνους χρόνους επινόησε, επένεσε και επεδίωξε αυτές τις αξίες. Και εύχομαι τα συμπεράσματα των εργασιών σας, τα πορίσματα των εργασιών σας, να γίνουν αξιοσέβαστα και εφαρμόσιμα, όπως αξιοσέβαστα και συχνότατα εφαρμόσιμα είναι όσα μας υπαγορεύει ο Έλληνας συνήγορος του πολίτη, ένας θεσμός που σε λίγα χρόνια κατόρθωσε να αποκτήσει κύρος, γοητεία και υψηλή υπόλοιψη στους πολιτιακούς θεσμούς της Ελλάδος. Καλή επιτυχία στις εργασίες σας.
Σας ευχαριστούμε πολύ. And now we would like to invite the Minister of Interior, Mr. Makis Voridis, who is representing the Prime Minister, to address the plenary.
Good morning, everyone, and really, it's a great pleasure to be here with you and to give you also the greetings from the Prime Minister. We are all delighted that you're here in Greece, in Athens, in Sounio, and I just hope you're going to enjoy your stay, doing, of course, your excellent work. And I do think that the topic you have chosen is so interesting and challenging, especially concerning the institution of Ombudsman and how you can revigorate and reinvent and reconstruct in postmodern era, in postmodern times. And of course, the main challenge with postmodernism is that it comes after modernism, and modernism becomes very traditional quickly. So you do have, all this transition, and the President of our Parliament reminded us of the classical era, to tell you the truth, this kind of eternal dialectic was one of my main concerns when I was studying jurisprudence in London. And the topic then of my work was the relation, the dialectic relation between Plato's Symposium, which of course is Antiquity and Classicism, and Michel Foucault's History of Sexuality. And the dialectic of it was actually, because, you know, Plato's Symposium is talking about love and the ideal of love, and the History of Sexuality of Michel Foucault addresses in a postmodern way the same issue. So this type of, let's say, of theoretical constructs and concerns really makes your topic very exciting. But coming back into reality and what we do in the Ministry of Interior and the relation we have with the Greek Ombudsman, I must thank dearly the Greek Ombudsman, Mr. Potakis, because I think they are important. We have municipalities, and we're talking about that, municipalities and regions. Yeah, they have a lot of work to do, trying to, let's say, to comply with the suggestions that the Greek Ombudsman has made. We need to think more about the execution of court orders towards the administration. I think we have a lot of work to do making the framework more functional and working better. So yes, there are things to be done, but on the other hand, I think that there is a great progress that we have made. And another thing that came to my mind, I was here, my dear President speaking, is, you know, normally in Greece, we're always proud to remember a glorious antiquity, the classical era. So Greeks, we are indeed very proud of this heritage, and we always like to refer to that. But to tell you the truth, you know, these years, especially after the financial crisis, I am very proud and standing in front of you as a proud Greek, not only for our glorious past, 2,500 years ago, but also for a present, because I think Greece is doing more and more. It's catching up. It's getting a country with, which is becoming actually more modern, which is becoming actually ameliorating from the institutional, financial, and that actually now could stand with, let's say, with pride in the international community, and saying that we have achieved a lot of things, we are doing a lot of things, we are doing better and better, and with the help of the Greek Ombudsman, I think we are going to be doing a lot more in the future. So we are really delighted to have you here. Prime Minister would like to be among you. Unfortunately, as you understand, there are business to attend, but we thank you for being here. We are delighted to have you, and we hope you enjoy your stay. And of course, we will keep a very close eye to your work, and we hope to benefit from the results of your work here. Thank you very much. Thank you.
Thank you very much. It is now the President of IOI Europe and Greek Ombudsman, Mr. Andreas Potakis, who will take the floor to start the conference.
Κύριε Πρόεδρε της Εθνικής Αντιπροσωπείας, κύριε Γενική Γραμματέα, θα μου επιτρέψετε να μιλήσω στα αγγλικά, αν και δεν μου δίνεται πολύ συχνά η ευκαιρία να απευθύνομαι ειδικά σε ομολόγους μου στα ελληνικά. Νομίζω θα διευκολύνει περισσότερο την κατανόηση και τη ροή. Καταλαβαίνω ότι και ο χρόνος του κυρίου Προέδρου είναι πολύτιμος και δεν θέλω να τον σπαταλήσω. Συνεπώς, θα γυρίσω στα αγγλικά και θα απευθύνω ένα σύντομο καλωσόρισμα στην αγγλική γλώσσα. Um, dear Speaker of the House, dear Secretary General, dear guests, friends and guests, and dear colleagues. First of all, let me also, on my behalf, welcome you to the conference of the European section of IOI under the title Ombudsman Reloaded, Mandate and Operational Framework in a Postmodern Era. A conference that is organized on the occasion of the biannual General Assembly of our network that took place yesterday. During the proceedings of our General Assembly, our colleagues, members of the IOI Europe, we reaffirmed our commitment to working closely and to strengthening even further our cooperation. And I am particularly pleased to inform our guests that during the General Assembly meeting yesterday, the peer review mechanism was launched, officially launched. The peer review mechanism being an instrument so indispensable to ombudsman institutions as it will permit us not only to identify strengths and weaknesses within our own constitution and modus operandi, but also the extent to which each of our institutions meets the minima criteria, the minima standards of an independent, impartial, and effective authority, standards that have been agreed upon by members, countries, governments within the Council of Europe, but also within the European Union. In the course of our meeting today, we will be revisiting some of the most central topics that have, in fact, dominated discussions among ombudsmen in the past few years. And I cannot but echo what my speaker mentioned earlier, the irony of the title, that although we are talking about a postmodern era, the topics that still concern us are so traditional, perhaps so coming from the old times. So first, how can we better accommodate the ever-increasing human rights-related mandates within our area of competence, with a view to ensuring respect for the rule of law, legality, and the democratic principles? Secondly, what are the challenges, but also the opportunities, that the new digital era in the state functions and public administration bring? Thirdly, how can we as ombudsmen more effectively reach out to people, and especially to the most vulnerable, marginalized parts of our society? It may well be a fact that we live in a time where quality of life and respect to the value of man in our continent is historically at its highest level, at an unprecedented level in human history. But however, and unfortunately, this does not mean that even within our democratic, inclusive societies, new and pressing challenges do not require our attention and intervention. Phenomena of illegality or maladministration in the function of the state structures are ever present, while new crises, social and economic, are becoming the order of the day. The present conflict in Ukraine and the extraordinary increase of energy prices already affect and will continue to do so the everyday lives of our fellow Europeans. In the hope that the ensuing discussion will offer us a chance to continue our work with the same passion and commitment, hopefully allowing us to become a bit wiser than before, let me thank you all for being here, for your presence, for your contributions, and for your participation. And I wish us all a very productive day. Thank you very much.
Now we will have a really short break of 3 minutes, and we will continue immediately with the first session. Okay, so may I have your attention, please? We will start with the first session, entitled Ombudsman as a Human Rights Institution, and it will be Mr. Marc Bertrand, Ombudsman of Wallonie and member of the Board of Directors of IOI Europe, who will chair the session. The floor is yours.
Thank you very much. I will speak in French. Tout d'abord, comme vous l'avez constaté, je ne suis donc pas Maria Lucia, je suis Marc Bertrand, et je dois vraiment excuser notre collègue Maria Lucia qui présente son rapport annuel devant son Parlement. Donc elle est toute excusée, c'est évidemment une de nos missions prioritaires, c'est d'abord de rendre compte à nos parlements. Elle regrette beaucoup de ne pas être parmi nous durant cette conférence. Ensuite, le thème de notre conférence, l'Ombudsman en tant qu'institution des droits de l'homme, ce n'est pas à vous que je dois apprendre que depuis maintenant 3 ans, des documents internationaux importants insistent sur la dimension de protecteur des droits de l'homme pour les institutions de médiation. Je pense évidemment aux principes de Venise, qui ont indiqué cela dans le titre même des principes. Je pense évidemment à la résolution de l'Assemblée générale des Nations unies, qui insiste également sur la dimension de protecteur des droits fondamentaux comme mission des ombudsman. Alors c'est une évolution très intéressante pour toutes nos institutions. Certes, une partie de nos institutions ont déjà cette mission d'être défenseurs des droits fondamentaux. Nous le savons. Une autre partie ont des missions plus traditionnelles d'ombudsman chargées de traiter les conflits, les différends entre les citoyens et les services publics. Mais toutes, je crois, ont aujourd'hui vocation à se transformer petit à petit en tant qu'institution de promotion et de défense des droits fondamentaux. Et nous le faisons déjà au jour le jour, que nous soyons là pour défendre les droits politiques, les droits économiques, les droits sociaux, les droits culturels, les droits à l'éducation. Tous ces droits, nous le faisons déjà à nos niveaux, que nous soyons un médiateur national, un médiateur régional, un médiateur local, nous agissons déjà à ce niveau. Peut-être que nos interlocuteurs ne nous le reconnaissent pas encore directement, mais nous savons que nous sommes aussi déjà en partie des institutions de défense des droits fondamentaux. Alors le panel que j'ai l'honneur d'animer ce matin est assez original, puisque vous ne voyez pas à cette place-là Andreas, Rob ou un de nos collègues pour défendre les ombudsman. Ce sont plutôt des partenaires qui sont nos amis évidemment, mais qui vont nous faire part de leur vision de cette thématique. On peut déjà dire que nous ne sommes pas concurrents, mais voilà, il est intéressant de voir quelle est votre approche de la thématique. Alors vous avez les noms de nos panélistes sous les yeux. Michael O'Flaherty, qui est directeur à l'Agence des droits fondamentaux de l'Union, qui nous donnera un message virtuel dans quelques minutes. Monsieur le juge Ioannis Tsitstakis, excusez-moi, qui est donc juge au titre de la Grèce à la Cour européenne des droits de l'homme. Madame Maria Daniela Marouda, qui est présidente de la Commission européenne contre le racisme et l'intolérance au niveau du Conseil de l'Europe, sauf erreur de ma part, qui est également professeur à l'université Panteion à Athènes. Et Monsieur Jonas Grimheden, qui est Fundamental Rights Officer à l'agence de contrôle des frontières de l'Union, Frontex. Alors, je ne vais pas vous présenter leur CV. J'ai été consulter leur curriculum sur Internet. Je pense qu'il me faudrait au moins 10 minutes pour chacune des personnes, tellement vous avez vraiment un parcours important dédicacé pour une grande partie aux questions des droits de l'homme. Et franchement, je remercie aussi nos amis de médiateurs de Grèce de vous avoir invité, parce qu'ils ont invité en notre nom des personnalités particulièrement prestigieuses. Et je vous remercie déjà d'avoir accepté de participer et de nous faire part de vos réflexions. Voilà, j'ai déjà beaucoup trop parlé. Je propose à nos amis de la technique de lancer l'intervention de notre collègue Michael O'Flaherty de l'Agence des droits fondamentaux.
I'm very pleased to greet you at the beginning of this meeting of... Hello. Hello. I'm very pleased to greet you at the beginning of this meeting of the European branch of the IOI. I'm very sorry that I couldn't be with you in Athens. I'm missing the opportunity to spend time exchanging views on some of the greatest issues we confront here in Europe with you, Andreas, and with the other ombudspersons. I'm conscious that you meet in a very challenging moment for European society. We're confronted by worrying patterns of human rights abuse, be they civil and political or socio-economic. We see the attempts to damage or even destroy the foundational elements of the rule of law in our states, undermining independent courts, threatening civil society, and on it goes in so many parts, too many parts of our Europe, including indeed also erosion of the space for a free media. And then on top of it all, we have the horror of the Russian aggression in Ukraine. It, in and of itself, is the single greatest point of human rights abuse on our continent right now. But of course, its implications spill out right across our continent in so many ways. And so what do we need to do now to push back against these levels of human rights abuse? Well, in the first place, we have to invest in and strengthen the architecture for the protection of human rights. And I'm of the view that ombudspersons are central to that architecture. That's why I so very much welcome the high attention that you're given to the role of ombudspersons in standing up for human rights across our societies. That said, if we are to put all that confidence and trust in ombudspersons to carry out this central human rights role, then we have to invest in ombuds institutions. We have to make sure that you are adequately resourced. We have to make sure that you have clear, strong mandates which are matched by those resources. And of course, at all times, we have to assiduously stand up for your independence. The Fundamental Rights Agency, for its part, will do what it can in working with you with this ambitious set of goals. We will do it through our research. We will do it through our accompaniment in the field, something we've done now in so many countries. We will do it through a respectful and continuous dialogue, whereby we listen to you and learn from you, so that we can better calibrate what we do with you in defence of the human rights of everybody in our societies. I wish you well for the conference. Thank you.
Voilà, nous remercions M. O'Flaherty qui vient de nous lancer l'invitation à coopérer avec eux. C'est en droit de ligne avec ce que nous avons décidé hier en Assemblée générale et nous allons répondre à son invitation, Monsieur le Président. Donc maintenant, c'est avec plaisir que je vais passer la parole à Monsieur le juge au titre de la Grèce à la Cour européenne des droits de l'homme, Monsieur Ktistakis. C'est compliqué pour moi. Je vous passe avec plaisir la parole. Merci beaucoup.
Bonjour, monsieur. Merci, monsieur le médiateur. Mon nom est compliqué même pour les Grecs, alors il ne faut pas... oui. Mais c'est le droit, mon droit à la famille, alors mon droit au nom familial. Let me address to you in English, and the title of my intervention in this panel is the following: an ombudsman in Strasbourg, amici curiae before the European Court of Human Rights. According to the Latin dictionary, the terms amici, amicus, and amici curiae are under as the friend of the court. It is the voluntary, friendly support of the work of the judiciary by states, international organizations, legal entities, or individuals who, without being parties or interveners in a particular dispute, know or want to set light on the facts of the litigation or the scientific issues raised in this particular dispute. Apart from the Latins and the ancient Greeks, amici curiae are nowadays known in the Anglo-Saxon world, especially in the United States, in some continental law countries, and countries with a relatively mixed system like Greece, but also before the international courts. There are at least 7 international courts which provide in their rules the participations of amici curiae to the proceedings before these courts. Of course, I will speak for the case of European Court of Human Rights, and the first request for leave by an amicus curiae before the European Court of Human Rights was made in 1979 in case Winterweb versus the Netherlands. But after the entry into force of the 11th additional protocol to European Convention of Human Rights, 1998, the contracting parties, for the first time with this protocol, explicitly committed themselves to the representation of amici curiae in the procedure. Then, from 1992, in Article 36, there are 3 paragraphs with details provisions about the participation of amici curiae before the Strasbourg Court. Today, if we like the statistics, the European Court of Human Rights has around 24,513 judgments, and amici curiae have been participate to proceedings in 1,291 of these judgments. Is about 1.32% of the judgments rendered by the Strasbourg Court. Of course, the friends of the European Court of Human Rights are, as I said, both the states, which are not parties to the case, to the particular case before the European Court of Human Rights, but also they are international organizations, individuals, and legal entities. I have an exhaustive catalogue of international organs who have already exercised their right to amici curiae, and among others are the United Nations High Commissioner for Refugees, the Office of the High Commissioner for Human Rights, the United Nations Special Rapporteur on the right of everyone to the employment at the highest attainable standard of physical and mental health, the United Nations Special Rapporteur on the promotion and protection of human rights and fundamental freedoms and the fight against terrorism, the European Commission from the European Union, the OSCE, the High Representative in Bosnia and Herzegovina. The Venice Commission also has, let's say, participated to the proceedings under the provision of Article 36. And of course, some of the Ombudsman, European Ombudsman, have also exercised the right to amicus curiae under Article 36. I mentioned, among others, the Czech Public Defender of Rights, the Irish Human Rights Commission, the British Equality and Human Rights Commission, the British National AIDS Fund, Slovenian Human Rights Ombudsman, Public Defender of Georgia, the Greek Ombudsman, Slovakian Public Defender of Rights, the French National Advisory Commission on Human Rights, and the French Defender of Rights. Which are the conditions of admissibility for the exercise of the right to amicus curiae? The first basic condition is that the amicus curiae is not the applicant, and of course is not the defendant. Concerning especially the public entities, like the Ombudsman or the national commissions, which are public entities, public law entities, and they have a special administrative or financial relation with the state, which can, in a particular case, can be the defender's state before the European Court of Human Rights. The case law of Strasbourg said that this is independent. Every human rights institution and the Ombudsman, the National Ombudsman, despite the fact that there is support from the defending state, it can be considered as a third party, then can exercise, as I refer also to many examples, can exercise the right to amicus curiae before the court. Of course, amici curiae have to comply with the time limits and the form of participation to the procedure before the court of Strasbourg. These conditions and these admissibility conditions are defined in Article 36, paragraph 2, and of course in Article 44 of the Rules of the Court, which are public, the rules of the court, and they are, you can find the exact provisions, detailed provisions in our internet website. There are two types of participation of amici curiae in Strasbourg. The first, which is the common and the basic, are the submission of written remarks in a specific case. And the second, which is very exceptional, but still exists and has been exercised in some specific cases, is the right to be present to the hearings before the European Court of Human Rights in the Grand Chamber or in the Chamber, and have the time to address to the court and raise the issues which are, let's say, the issues that the amicus curiae wants to raise for the specific case. As I said, many ombudsmen from European states have been granted the leave to participate as amicus curiae before the European Court of Human Rights. Actually, there are more than 50 cases where the ombudsman have been, let's say, granted this specific leave, but only 11 of them have been already, only 11 of these cases, the court has already delivered the judgment, the respective judgment. I want to mention the most important case, which is the case of the Grand Chamber, the case, and now, Monsieur le Médiateur, excusez-moi, I have to pronounce a very difficult name, Gudumdur Adri Attrason versus Iceland is an Icelandic family name. There are not only the Greek names are difficult, are also at least the Icelandic one, which is the famous case rendered by the court in December 2020 about the independence of the national judiciary. Then in this case, and there was also a public hearing, and the public defender of Georgia and the Commissioner for Human Rights of Poland have been intervened as amici curiae. And it is, for me, very important, not only because it's the only of the 11 judgments relative to amicus curiae which has been delivered by the Grand Chamber, but also because it is the only, again, of the total of 11, where the Ombudsman were not related with the defending state. In other 10 cases, in other 10 judgments, the Ombudsman have been intervened, have been exercised the right to amicus curiae because, or let's say, they have the interest because the defending state was the state of their, I can say, nationality. Of course, in the judgments, you can see the relative paragraphs of the summary of the written comments of amici curiae, including the 10, the 11 where your colleague from different European countries have already intervened, and you can confirm that in the most of the cases, the Ombudsman's positions were not, in contrary, were, let's say, in favor of the applicant and not of the defending state. This is very clear from the judgment. And I can say that also the court has exercised all these years in 1,290 cases where the leave to participate for amicus curiae have been granted by the court, has exercised this right with, let's say, not strict rules. And sometimes, according to Article 36, the court itself has invited some amicus curiae to elucidate difficult questions raised by the facts of the particular case. I can just refer to one example, and this example is a case where both the United Nations missions in Kosovo and the K4 have been implicated, and the court asked from both these two UN bodies to intervene and to, as amici curiae, and to participate to the proceedings. Then the court, let's say, is not afraid of, is in contrary, is very positive to invite itself also and to listen all the different approaches in a specific case. My concluding remarks, Monsieur le Médiateur. First, according to the case law, there are not specific criteria for who may be granting leave to appear as amici curiae before the European Court of Human Rights. Of course, the provision said that everyone who has to contribute to the administration of justice can be granted the leave to be an amicus curiae before Strasbourg Court, but the case law doesn't define, let's say, organize which are the real criteria to grant a leave. Then the conclusion, according to the today situation of the case law, is that almost everyone can, individual or legal entities or ombudsman, can intervene to the court as amicus Courier. The second concluding remark is about the, let's say, the nationality of the amicus curiae. I said in the beginning that the Anglo-Saxons have developed this kind of friends of the court, the amicus curiae, and today you can say that the most of the amicus curiae before the European Court of Human Rights are Anglo-Saxons NGOs. But of course, there are many French NGOs the last 2-3 years, and also they are from other countries. For example, le défenseur des droits qui vient from France and the Commission nationale consultative des droits de l'homme are very, very active the last 2 years and in French cases. And the next 2 or 3 years, there will be more than 30 judgments that you will read to the internet about their intervention. My last point, I think, concern also the court and, of course, the ombudsman and this type of intervention, the amicus curiae status. I think that there can be some improvements the next time to the procedure for amicus curiae before the Strasbourg court. One such improvement may be the publication on the court's website of all written remarks of amicus curiae, including the ones coming from the Ombudsman. I think this will be a very crucial improvement, like the one introduced with the 11th protocol in 1998 that I have been already mentioned. And I think that this will have only positive results because the written remarks of amicus curiae who will become public, they will, let's say, develop, they will develop many analyses of the positions and the comments of amicus curiae, and also will help the next amicus curiae to encourage them and also guide them how to intervene to the proceedings before the European Court of Human Rights. In my view, the statistics coming from the International Tribunal for the Law of the Sea, which is the other international court, one of the other international courts who accepted and provided and encouraged the amicus curiae and also published the written comments of amicus curiae to the proceedings before this international court, then the results are very, very positive. Monsieur le défenseur des droits, merci beaucoup.
Merci beaucoup, Monsieur le juge Ktis Takis, pour nous avoir, pour une partie des participants, rafraîchi les conditions de l'amicus curiae et certainement pour une autre partie de nous avoir exposé concrètement ce mécanisme. Et I propose to reserve the questions for the last part of our meeting before the break. Thank you very much once again. I'm going now to give the floor to Mrs. Marouda, as I introduce you as the chair of the European Commission against Racism and Intolerance at the Council of Europe. Please, you have the floor.
Thank you very much. And thank you for the opportunity to be here after years of being online, seeing each other. We slowly started also as a European Commission Against Racism and Intolerance monitoring visits. We have tried to go through in the last year and catch up, being present in member states of the Council of Europe, because we felt this was a particularly testing and difficult period, and we had to be present. And this is what I would like to share with you today. So my brief intervention will be on two parts. One is the key requirements for the equality bodies, ombudspersons, to be a human rights institution. And the second, typical shortcomings we have witnessed during our monitoring visits. I will mention shortcomings with specific examples from reports we have already published, because this is the rule. But very soon, within the next 6 months at least, we will be ready to publish a lot more reports from our 6th cycle. Just to say that every cycle lasts for about 5 years. Every 5 years we have monitoring visits on all members of the Council of Europe, but this cycle will last a bit more because of the pandemic, so we are now almost halfway through. And the first part in all our reports of the 6th cycle is devoted to equality bodies. So this already is highlighting the contribution or our common understanding of the key requirements for equality bodies on the fight against racism and intolerance. Secondly, we organize every year the annual seminar for equality bodies and NGOs. Last year it was on communication, on new strategies, because we found out that this is one of the most important aspects for our common work. And this year, we will have our annual seminar on intersectionality, which is another important key term, cross-cutting, and we really need to put context in that term. I'm very happy we have with us today Tena Simonovic-Huiz, also a vice chair of ECRI, and also chair of the equality body in Croatia, and was the chair of Equinet. And a few years ago, time passes, flies, our general policy recommendation number 2 was revised on the equality bodies, how equality bodies, ombudsman can be effective and independent. And this is how I will begin this intervention. So what we have seen as key requirements is, first of all, that we need an extended and a deeper or stronger mandate for equality bodies to be able to do the work envisaged also by our revised GPR. And this means that equality bodies should also have the competencies to intervene in the legislative procedure. Amicus Curiae is one excellent way of doing so, but also bring cases before national courts in the institution's own name and intervene in legal proceedings as third-party expert or amicus curiae. So this would be very important. And also, in the mandate, an important aspect is prevention. So awareness-raising campaigns, research, together with universities, NGOs, other partners, surveys are extremely important. And this is what we have seen. Then the second point, independence requires budget, and budget should be adequate. And when we are saying budget, adequate staffing, and who chooses the staff is of particular importance as well. So these are aspects that are key. And the third, every time there are legislative changes, extending the mandate, merging bodies. This should be only after prior consultations, with cautious steps, listening to the people, listening to the institutions, and not just having changes all the time. And this was very worrying during the pandemic, when a lot of laws passed without any discussion, and people don't know. A fourth smaller point with these changes is also a tendency to gather or to merge equality bodies under one institution. And this means that discussions are important. In our general policy recommendation number 2 on equality bodies to combat racism and intolerance at national level, ECRI considers that there may be one or more equality bodies in a country, but if instead of having more than one bodies, there are different thematic deputy ombudspersons, for example, then their mandate and their role should be specific, equally independent, with their own budget sometimes and their own staff. So this again is important for a full spectrum of responsibilities, also for the deputies. Let me now be more specific. There are cases in Europe where ombuds institutions have not been designated as equality bodies. Specialized bodies were established for that person, and at the same time, in a number of Council of Europe member states, ombuds institutions have been designated. In such cases, functions and competencies need to be divided in a complementary way between the respective equality bodies, and conditions for proper synergies could be created. So if there are more, we need synergies and complementarity. As in the case in Greece, the Ombuds institution is designated as the only equality body, and therefore there are different challenges. As ECRI, we cannot promote one particular model over another. However, we are attentive to whether equality bodies, whatever their form, meet key requirements. One core function should be the promotion of equality, as well as the prevention and elimination of discrimination and intolerance, including structural discrimination, which we have seen in the pandemic, and hate speech. The equality body should also promote diversity and good relations between persons belonging to all of the different groups in society. Another core function is to support people exposed to discrimination and intolerance and to pursue litigation on their behalf. Coming to another key requirement, the minimum list of discrimination grounds to be covered by an equality body includes race, color, language, religion, citizenship, national or ethnic origin, sexual orientation, and gender identity, as well as what we would call multiple or intersectional discrimination on these grounds, and any other grounds such as those covered by Article 14 of the European Convention on Human Rights, and therefore equality bodies should integrate always these grounds, plus what we try as ECRI, and it's not always easy, a gender perspective. Both public and private sectors should be covered by the equality body mandate. And yet another equality body function, albeit optional, is taking decisions on complaints. It goes without saying that the establishment and functioning of equality bodies should have a strong legal basis. Equality bodies should be independent from public authorities while enjoying sufficient resources to operate effectively. Now, the aspect that I already pointed out, every change should be preceded by consultations. In this connection, it cannot be overemphasized that any substantial change in the legislation altering the national original equality body architecture should be handled with great care, preceded by adequate consultations, and only aim at enhancing effectiveness. Consultations should involve all stakeholders, including representatives of any existing equality bodies and of the civil society. Such consultations should allow sufficient time for the views of all these actors to be carefully taken into consideration. What I just said was stressed by the Council of Europe's Venice Commission in the context of a merger of equality bodies in Hungary with an ombuds institution, in one ombuds institution in 2021, in October. We had our monitoring vision meeting in Hungary in November, so we had the opportunity to discuss how this worked in practice. The Venice Commission indicated that there are risks associated with a merger of this type, in particular when the bodies and institutions concerned have different traditions, a different culture, as we say, different legal procedures, and different approaches. It takes time for such a merger. It cannot be decided so fast. And if this is the case, the merger may hamper future effectiveness. Similarly, it is essential to go through proper consultations and keep in mind the objective of enhancing effectiveness whenever a new equality body or a human rights institution is created, whether it is at national or at regional level. Any new equality body should comply with the requirements of the GPR2 I mentioned earlier. And this is the case, since we have the opportunity to have you chairing this meeting, of the Flemish equality body. We are currently taking part in this type of consultations for a new legislative proposal, and this is in the heart of the discussions in Belgium at the moment. So it's very important and will have an impact on the work of a national human rights institution, UNIA. Let me now turn to what we have seen as typical shortcomings, and I will only mention reports we have published on our 6th cycle. Shortcomings in resources and follow-up to recommendations of ECRI. On Albania, we recommended that the Office of the People's Advocate, which is the Ombudsman in Albania, receive the necessary financial and staffing resources to fully and sustainably cover all aspects of their mandate. The follow-up given by the authorities to the recommendations of the People's Advocate should be strengthened with a view to enhancing even more effectiveness. There are also shortcomings in the extent of the equality body's mandate as it concerns the independence, the discrimination grounds and forms covered, sectors covered and competencies, and this would be the case in Austria, where ECRI recommended that the authorities should extend the Ombudsman's mandate to cover explicitly hate speech, the grounds of color, language, citizenship, and gender identity, and the intersectional aspect of discrimination. To make sure that his mandate covers all areas of public and private sector, provide him with the competencies to intervene in the legislative procedure, represent people exposed to racism and discrimination before the courts, bring cases in his institution's own name, and intervene as amicus curiae, third party or expert, and stipulate that the Ombudsman publishes annual reports for discussion by Parliament and by the government, as we have seen was mentioned by the President of the government, of the Parliament in Greece, discussing the Ombudsman report of 2021. Shortcomings in the coverage of the Ombudsman competencies to make inquiries and collect evidences in the Czech Republic. ECRI recommended that the authorities extend the areas of inquiry and of obtaining evidence of the public defender to the private sector, and that they grant the public defender the right to initiate court cases. And now on the threats to the independence of the Ombudsman, ECRI in the Slovak Republic, when the Ombudsman has come under attack, including by a member of a government, with regard to her human rights protection work, which could undermine her independence, in our 6th report, recommended that this institution should not be subject to any interference by the state, political parties, or other actors. You see, this would be typical shortcomings that we, as ECRI, recommend the governments, and in the last cases, we also recommend it as our prior, let's say, recommendations, which means we come back in 2 years' time and see what has happened and not wait for the full period of 5 years. Thank you very much.
Merci beaucoup, Madame Marouda, excusez-moi. Et merci beaucoup pour votre intervention qui nous a permis de mieux connaître la portée du mandat de la Commission européenne, et j'étais particulièrement intéressé par les exemples concrets que vous avez donnés dans la deuxième partie de votre intervention, ce qui nous montre aussi la diversité de vos champs d'intervention. Une fois encore, nous aurons l'occasion de répondre aux questions tout à l'heure, et ça me permet l'opportunité to give the floor to our last speaker for this session, Jonas Grimheden, who is, as I remind you, the Fundamental Rights Officer at the EU agency Frontex. Please take the floor. Thanks. There is a PowerPoint presentation.
Thank you, Mark, and thanks a lot, Andreas, and the fabulous team that got me here, and I assume also you here. Fantastic to be with you today. I would like to do 3 things. I would like to explain the title here, if I am or not an ombuds institution with a human rights mandate. I would like to explain a little bit about my mandate, and thirdly, I would like to engage you in cooperation where that is helpful for you. I already cooperate with some of you, and I would like to see how we could do more of that. And I have a little button here that enables me to switch between the slides, so with a bit of luck, this works. This slide is not a test of your eyesight. It's not to boost my own title, but this is an overview of the title that I have in the different EU languages of the EU legislation, so European Union legislation that governs my role. And I just grouped them here very simplistically under 4 headings. So in some languages, I'm an officer. In some, I'm a clerk or a servant. Yet in others, I'm a responsible or a manager. And the point I wanted to make in my own mother tongue, I'm an ombud. So we've heard a lot about Latin from the judge and about Greek earlier today. And here's finally a word that is neither, with other roots, as you know very well. So I hope with this that you will see me as a very junior, very small, but hopefully still a little bit of an ombuds person. I also want to speak to what we just heard about the importance of independence, something you know very importantly, and I learned over dinner, the very nice dinner yesterday, that some people in this room have contributed to the independence that I enjoy, or my post enjoys. So this slide is full of acronyms that you don't need to know, but it's an overview of the structure of the European Border and Coast Guard Agency located in Warsaw, where I work, also known as Frontex. And all the entities are responsible and report to the executive director, or if he or she is not in the post, to the deputies. But I report to the management board. So I wasn't recruited by the agency, I was recruited by the management board, and I have no formal responsibilities towards the director or the executive director of the agency, but only to the management board. And thanks again to those of you who were influential in shaping the mandate in this way. And I think I will say a few more things in a little bit about the nature of the independence, but I can say in short that I feel and have full independence. So talking about staff and budget, I have a separate budget. I can ask for more money, I get more money. I have separate staff that I recruit directly and in that way and in all the ways that I seem and deem necessary, I feel and act independently. If we reminisce about the roots of the about the European Border and Coast Guard Agency, it was introduced some 17 years ago with very little concern for fundamental rights, maybe logically because the mandate was very limited. As the mandate has grown and the budget, you can see that on the left side of the slide, and the staff has increased from 24 to 2011 to 2016 and 2019. Also, the number of references that you can see in the little green boxes to fundamental rights, to human rights, have increased. So logically, with the increased responsibility and mandate of the agency, also the references to fundamental rights, to human rights have increased. And also the measures that have been introduced to ensure fundamental rights. So from early on, a consultative forum, a fundamental rights officer, my post, but with less independence guarantees back then, and from 2019 with very, very strong independence guarantees, together with also a minimum requirement of fundamental rights monitors, so people that work for me and monitor the field, in the field, all the EU's external borders. I have a number of tools, and I will not confuse you with all the nitty-gritty of this slide, but simply to say that we have an internal reporting mechanism that is called a serious incident report, so typically a typical law enforcement mechanism where everyone in the organization, including national authorities that work with us in the field, if something occurs that is out of the ordinary, they have to report. If it relates to human rights, they have to report directly to me to avoid that it's filtered or altered on the way. There's also a complaint mechanism for persons that are external to the organization that increasingly is running with increasing number of complaints. And there's a clear link also here to national ombudsmen or ombuds institutions. So for instance, in one case, or more than one case, but in one particular case, it relates to the situation in this country. A person with the connection to Frontex has been in a particular situation, and then we investigate from my perspective to some extent, but we also then can hand over and see if the national ombudsman can pursue the case, and that's actually the situation with what I have in mind here. And again, not to test your eyesight, but just to remind me of what to say. Since I took office just about a year ago, we've spent 500 days in the field. So I'm not saying that to brag, but simply to say that we are very operative. We are on the ground. So this is not missions like this one, but missions where we go to the borders, land, air, or sea, and monitor and try to see, prevent, but also to report on and train, if you will, border guards. And as you can see, if you can see, the countries, we've been to 10, 15 countries so far, and you can see that we've made a lot of effort to go to two particular countries, Greece and Lithuania, risk-based from my side, where I see the biggest problems. We also are active on return flights, so forced return monitoring typically, where we've been on some 30 return flights since I started, and you can also see in the lower left corner the number of complaints by the year that are increasing. And in the lower right corner, simply that the staff that I have at my disposal currently a bit over 40, but in a few months we hope to reach 65. So it's also a substantive number of persons. Last slide, Mark, you will be happy to know. With this, I would like to wrap up by saying that as everything in the European Union, it's complicated, a bit like Belgium, but even bigger than Belgium. My mandate is very clear when it comes to Frontex staff. So staff that works for Frontex, border guards, etc. It's very clear. I have a full mandate, full access. I ask for documents, I ask for phone records, whatever, I get it. With what is called the joint operation participant, so this is where Frontex has a joint operation. Actually, technically, I think the coast here would fall into one of the joint operational areas. Participants in this joint operation, also from the Greek side, would fall within my mandate. But of course, here I would have much less traction because I'm not Greek, they are not responsible towards me, and that's where it's very important to have national ombuds institutions or other entities that can attack the problem from their perspective. We also have a mandate, I also have a mandate to some extent in the joint operational area where there is no Frontex involvement. So even if something would happen here, if it somehow would have a spillover effect on Frontex activities, I could claim to have a mandate. But of course, even less traction if I try to push it. And finally, the light blue box here, the fourth box in the center of the slide, I am authorized under the EU regulation that guides my mandate to advise the agency and the management board on if a situation is too problematic when it comes to human rights, fundamental rights in a country altogether, to pull out, to limit, to somehow restrict cooperation with that country or advice to that country. And I think that's something that we are increasingly advocating. It's not an ideal solution because then Frontex is leaving, and I think Frontex is a great transparency mechanism. We have, just in this country, I think around 500 officers working from Frontex, directly responsible towards Frontex, and that they are obliged to report on human rights to me, and that's of course a great transparency mechanism. And to conclude then, finally, just to reiterate what I flagged in the beginning and a couple of times throughout the talk here, for my mandate to be effective, I really need to work with you, where you are willing to do so, of course. And I mentioned the Greek Ombudsman already. I had a really good discussion over dinner with Tena and the Croatian Ombuds Institution yesterday, and we've talked before in various ways. We have a memorandum of understanding, which we have to have with countries outside of the European Union where we work. So we have with the Albanian Ombuds Institution. And we have in the pipeline a similar agreement with Montenegro and with Serbia, with the Ombuds Institution there. And then I conclude an agreement also to ensure independence, that it's not the agency, but my office that concludes these agreements. So I hope that this is a little bit of an introduction to my role as maybe an ombuds institution of some sort in an EU context. I try to explain a little bit what we do, and I try to invite further cooperation with Albania, with Greece, with Croatia, but surely there would be, I know there are other countries where we work. So with that, thank you very much.
Thank you very much, Jonas. I think that we can consider you as our colleague now, because personally I had no idea about the existence of your mission within Frontex, and also now after this description also all the guarantees on which we are very sensitive, the independence. I think it was very important to know you more, and I hope that your call will be heard by our colleagues to develop cooperation with you. Thank you very much. Okay, now that's 11 o'clock. I think normally we have the coffee break, but I suggest to have some minutes, if Andreas allows me, some minutes of discussion, and because it would be annoying that we could not have a discussion with our panelists. Sorry? Yeah. Okay, I give the floor to the room. Who wants to take the floor? Please, don't be too shy. We have to take benefit, and also the person who are behind the screens. I don't see any hands. Okay, our colleague from Albania.
I don't have a microphone, so I guess.
Is there a micro somewhere?
Can you use this one?
Yes.
I thought okay, sorry. Thank you to all the panelists. My question actually was for Jonas. And I thought we could do this even over the coffee, but it might be of interest for other people. At our institution, we have only 3 certified officers to work with Frontex. We would like to know how we can have more of our staff being certified. Me, myself, have been in some of the operations without being certified also. So I would like to know how to make that work better. Thank you.
Is it a short answer?
Yes, I think we could maybe do more.
Okay.
Yeah.
Other colleagues? Yes, please, our colleague from Croatia.
Well, I just really wanted to thank IOI for making us think about some of the most difficult topics in our mandates. And I'm quite sure those colleagues who only have the Ombudsman mandate are working with human rights, and working with human rights more and more because it has become unavoidable. And it's in the Paris Principles, and it's, you know, in Venice Principles that we, as independent institutions, work on this. But also those of us with multiple mandates are faced internally as well as externally through expectations of the media, of our parliaments, with so many questions. And I'm so glad we are discussing this as ombudsmen and ombudswomen. And I have to say, the relationship between the mandates of national human rights institutions and ombudsmen in some cases can get challenging. Between equality bodies and ombudsmen and NHRIs can get challenging. If it's within the same institution, it gets challenging internally. If it's between institutions, it gets challenging sometimes in our relationship. While Maria was speaking, I was looking at the list of our participants and looking how many institutions here are equality bodies. It's Greece, Georgia, Cyprus, Hungary, Poland, Bosnia, Czech Republic, Croatia, Kosovo. If you look at the NHRI component, it gets even more complicated. So dear colleagues, this will be a topic for all of us for the years to come, but also all our fellow institutions in our countries with the other mandates. And I think if we all agree that we have a common goal and that synergies are the way to go, we will progress in protecting human rights even better than we do right now. Thank you. And thank you for organizing this so important topic for this panel, IOI.
Thank you very much. I think your point is very, very clear and very important for all of us. Thank you very much. Please, I don't see if there are some people under the screen who wants to take the floor? No? I'm looking at my Greek colleague. Okay, Eleni Velivazaki. I don't know who is she or he. Eleni, you hear me?
Yes, hello, good morning. And thank you very much for all the very interesting presentations. It's really important to discuss the role of the ombudsperson and the possibilities that they have to act and intervene in the various bodies, even in front of the court. I would like to ask a question to the fundamental rights officer. If there is, we really appreciate your work and role in monitoring also human rights in Greece through the role of Frontex. Is there an opinion about Greece coming out soon? And is there a chance that an Article 46 be considered for the case of Greece?
Thank you, Eleni.
Thank you.
Yes? Where?
It's the same.
Okay, okay. Some person from the Human Rights Commissioner from the Russian Federation, I don't know who will take the floor.
Yes, dear Chair.
Okay.
The head of office is going to ask a question actually not related to the topic today, but related to yesterday General Assembly.
Уважаемый господин председательствующий, вчера на Генеральной Ассамблее Европейского региона МИО господин Потакис сообщил, что во время проведения заседания исполнительного комитета МИО, которое состоялось 12-13 мая этого года в Нью-Йорке обсуждался вопрос об аннулировании членства уполномоченного по правам человека в Российской Федерации в Международном институте омбудсменов. Просили бы вас предоставить дополнительную информацию по данному вопросу и направить ее в наш адрес в письменной форме. Заранее благодарю. Спасибо.
Dear Mr. Chair, dear colleagues, yesterday at the General Assembly of the IOI Europe, Mr. Patakis informed that during the meeting of the IOI Executive Committee, which took place on May 12-13 in New York, the issue of the revocation of the High Commissioner's membership in the IOI was discussed. In this regard, we will appreciate if you provide us with any additional information on this issue or send it to us by email. We thank you very much in advance.
You will reply after that. Okay, thank you very much. Your question is for yesterday, as you mentioned, but we will try to give an answer. Are there other questions for our panelists? No, because it will be the first and the last possibility. I check on the right, on the left, in the middle, no. Okay, I give the floor, Jonas, maybe?
Thank you very much, Yurida, for your question. I think I could talk for too long about this, but just very briefly to I think, explain the background. We don't have a certification process in that sense, but specifically for return monitoring, we would have a training course. So we are also responsible for a pool of national monitors, as well as our own monitors on return flights. And for this pool of national return monitors, we have a training course, and of course, the more the merrier. So anyone appointed to this pool could and should go through this training, and we would be very happy to have you. And I think next chance is late August for a week. So let me follow up with that separately. On Eleni's question on Article 46, so that is a provision in the regulation, in the European Union regulation, that guides, again, the work of the agency and indeed the European Border and Coast Guard as a whole, so including the member states. And Article 46 relates to this possibility that I mentioned to pull out, to restrict, etc., activity in a country. I have a mandate to issue opinions to the Management Board and to the Executive Director to recommend the use of this article, or, at least in my reading of the mandate, to also suggest mitigating measures that will, in a way, be leveraged, be pushed for with the threat of Article 46. So effectively, if you don't do this, we will recommend Article 46. That we have used in some contexts. I don't want to go into any details, but for instance, you mentioned Greece. We have issued opinions related to Greece where we have flagged that ultimately, of course, as per the regulation, Article 46 is in the cards. And there is a possibility for us to then escalate this pressure, this leverage, and that's of course something that I do with caution, but also as per my obligations under the EU regulation. So of course it's possible, and we are using this tool, but since it's typically for the Management Board to act and the Executive Director to act, I don't want to provide any more details than that at this stage. Thank you.
Thank you.
Just thank you to you.
Last word, or no? Please.
Thank you very much. Just one last word, maybe, to share with you what we see as expectations by the people on the ground from national bodies, like the Ombudsman. And what we see is that they feel they would like to hear more the views of the Ombudsperson every time there is a certain divide in the country. So not just whenever there are complaints, specific complaints, but when there are issues that divide the society, that divide social media, on legislative acts, on new proposals, on issues within the mandate, they want to hear the voices of the ombudsperson. So this is very important, and it's something that we always hear as coming from the ground.
Je voudrais remercier une fois encore nos panélistes pour, d'une part, leur exposé, leur réponse, en tout cas leur intérêt. Il y a beaucoup de messages qui ont été donnés par vous à nous, et donc nous allons essayer d'aller dans le sens de ce que vous avez dit, c'est très important. Je pense que, cher Président, que toute cette thématique, et notre collègue de la Croatie vient de le dire, on doit continuer parce que pour beaucoup, ok, ceux qui ont le mandat savent que c'est compliqué, mais vous l'avez le mandat. Ceux qui n'ont pas doivent aussi s'imaginer comment contribuer aussi au renforcement de la protection des droits fondamentaux dans leur travail de tous les jours. Je voudrais qu'on applaudisse encore une fois nos 3 orateurs pour les remercier pour leur excellente contribution. Merci beaucoup. And I would like to give the floor to Andreas in order to give some answer to our colleagues from the Russian Federation. Andreas.
Thank you, Chair. Although it is truly not the venue or the time to be discussing further what we discussed yesterday among ourselves during our General Assembly, just to repeat to our to the representatives of the Commissioner for Human Rights of the Russian Federation, as we mentioned yesterday, that a procedure has been launched within the IOI. As president, and I guess I can say as the head of the European delegation during the first discussions that took place in New York, our prime objective is for the procedural guarantees enclosed and stipulated in our bylaws to be fully respected. And I understand also that according to our bylaws, everything will be shared and disclosed with the Office of the Russian Commissioner for Human Rights, and ample possibility and time will be given to respond to any allegations or any complaints against the office. Thank you.
Thank you. How many minutes we have now? 15 minutes of those? Okay, 15 minutes, 15 minutes, because we have to save time. Thank you.
Dear colleagues, we are starting now with our second panel. It is not too easy to be chair after my colleague Marc Bertrand, but I'll try to. At the beginning, I'm delighted that I was given a chance to participate in this plenary session with you. And we are talking about digitalization, about using of new technologies. It is a big challenge for us, especially after coronavirus, when we were all online and our life changed. And I could say that especially people which don't have enough capacity, intellectual capacity, or they are not used to use the new technologies, are more handicapped as before. And I think that today's discussion will go on that way, how we can use new technologies, but bring new technologies near to the people, and not that public service will be far away from people, hiding themselves behind the new technologies. I would like to thank all the speakers which are here today. And for the first, I will give the word to dear colleague Raphaël Ribot to present his speech. Thank you.
Thank you very much. First of all, I must apologize that when I finish my intervention, I have to leave the room because I have to catch a flight later on. When they announced this conference, the Greeks chose the expression reloading the ombudsman, and it's a perfect expression after the COVID crisis, if we can call after today, and the Ukrainian crisis, the Ukrainian war crisis, that of course presents a lot of challenges to us, especially for the vulnerable people's rights. And in this sense, if we are talking about human rights and new technologies or artificial intelligence, I'm going to repeat the question I raised in Barcelona. Are we ombudsmen aware, and are we ombudsmen prepared to face human rights and new technologies and artificial intelligence? Most of us, with the exception of Sweden and maybe Finland, I'm not so sure about Finland, yes, Sweden, we were not born as institutions when Mr. McCarthy, John McCarthy, wrote about the science and engineering of making intelligent machines. That was at the beginning of the 50s, 1950s. Most of our institutions were not there. And as you can realize, in fact, recent results from a large survey of machine learning researchers predict artificial intelligence outperform humans in many activities. For example, translating languages, like they are doing already. It was said in 2024, that's a fact today. Or even working as a surgeon. In some specialties, they are already going far. What do I mean by that? That we can approach this subject to be discussed today as we have been doing as IOI in previous meetings. I would like to remember when we were discussing in Tallinn, in Tallinn, yes, the e-democracy, or when we were discussing in Riga, GDPR, or even in Brussels, or when we had recent discussions in the INO about also digitalization, or the just finished conference of the OMF in Marrakesh with a kind of document presenting some considerations and recommendations for all the Ombudsman family in front of those deeds. I don't know if the organizers want us to present different proposals on Ombudsman tools with new technologies. we could talk about what do we do as Ombudsman in visual recognition, on system experts, or in machine learning, or in deep learning, or in face recognition. For example, we work in face recognition with a lot of inmates when we visit every week any place where there is person with privation of liberty, of freedom. Or when we have our electronic office that any person presenting a complaint can follow at each second how is the complaint going. There are many, many different tools that we could use in our office to be in technological process of changes to get better results in our work. But I'm going to devote my intervention to the second dimension of this challenge, not the internal one. I'm sure my colleague at my right knows a lot about this, and she's conducting, as you know, a survey from IOI to all of us about those matters, and she published a lot of very important works on that. I'm going to devote myself to what we started as IOI in Barcelona in 2020, just before COVID, talking about artificial intelligence and human rights. At that time, we could say that maybe some of the presentations were telling us about facts that we didn't know. At least I didn't know. And some of my colleagues also were telling me the same opinion. We see a lot of private implementation and, of course, spreading facts on artificial intelligence, not so much in the public world, but they start every day more and more with improvement of different technologies entering in the field of the public administration and the public services, with a big potential for citizens' rights, even for solving in a very fast and efficient way a lot of problems for citizens' rights. But at the same time, with a possibility of falling in big risk that can harm citizens' rights. And that's what I would like myself to explain a little bit. In Barcelona, and you have all the different papers and presentations in English version for all of you, we were listening to the companies, to the big companies, the ones that up to now own artificial intelligence. We cannot forget that they go years light in front of us. We are a lot backward of what the big companies are doing. The big companies, I mean the ones that control now Wall Street, for example. I'm talking about the GAFAM, no longer oil or cars companies. It's Apple, you know about the different personnel that are in front of those companies. And we need not to catch them in a sense of competition, but at least, I want to say clearly, to control how they can influence in our rights, and especially in our clients' rights, in the rights of the people that we are in order to facilitate the guarantees of their rights. There is a risk of opacity, of discrimination, of violation of the right of privacy. Opacity understood as the double sense of lack of information or lack of intelligible information. Remember when we settled in all Europe, for example, with an EU directive, the smart meters counters in all the houses of all people for electricity. It's a very positive way of getting results on how much we are spending electricity. It's not so clear about how they can even somebody control what we are doing daily according to the data information that those smart meters provide. Discrimination on the presence of biases is also a risk of artificial intelligence application. There are always biases in society, and they will be present in artificial intelligence applications, and measures must be taken to correct them, because people women or men are going to prepare the algorithms and the machines and the tools to apply artificial intelligence. And there is a risk to data protection and privacy due to amplification of capacity of getting data. As myself, as Ombudsman, I had to discuss with MPs in Parliament a program called VISC, that they were trying to get hundreds of thousands of permissions of information of health files for research. And that's positive. It's positive if it is public, if there is no business behind, and of course, if there is no privacy, data privacy risk of harming. I would add that also there is a possibility, a risk of harming freedom of expression and even freedom of assembly of demonstration, according to what type of controls or of procedures that can be under all the devices of artificial intelligence. We need a specific regulation of those uses. The EU has an act in terms of working it. I know now there is 2 years to finish. You are going to correct me if I am wrong. I think in 2 years we'll have the act that would be transferred to a directive. The Council of Europe created, just when we were working in Barcelona, the CAHI, the Committee for Artificial Intelligence, and up to now we have recommendations, but we don't have treaties. We don't have changes in our treaties. And the recommendations are very important, but we need strong tools in legal terms, and more than legal terms, in right terms, to be able to face possibility of falling in those risks of harming human rights. The priority, in our opinion, would be to take care of the risk of prevention, to devote a lot of time to prevention and management of risk, as we did with the GDPR norms. The priority also will be transparency and intelligibility, the right to receive proactive information and intelligible information. Also, I would underline priority for accountability, very important requirement to lead to conceal the decision makers, the beneficiary of the application. Data minimization and quality. It's important to ensure that redundant or unnecessary data is not used. Emphasis must be placed on the need to verify the quality of data use. For example, in Spain, what happened with the so-called electric social bonds and spreading through the different social layers with a very big difficulties to get the most basic layers, those that they need more, the social electric bond. Of course, priority in human control and supervision, human control of machines of artificial intelligence. I find a lot of people saying, oh, look, the machine says, no, we need post-machine work, human control and supervision of that. Of course, equity in access. I was talking with some of my colleagues just before. Already in 2006, we presented in Catalan Parliament a report on broadband right access, and we sent it to the EU Commission. And still we are quite backward to verify that that's a real and European right. The principle of benefit to the other sea as another priority, or of course, the control authority. We must create, or international organization and body must create control authorities. Of course, the most important bias that we can find in this application is, as always, the gender bias, the gender perspective bias. Let me remember only what they say, the European Union gender equality. Women outnumber men in education, but female artificial intelligence professionals in the education sector make up only 25%. And in general, in ICT technology, only 19%. Only those figures express us the possible bias in how do we build our tools for fighting this kind of discrimination, in this sense, gender discrimination. That could be also something to analyze as age, socioeconomic status, race, geographical location, among others, that we must take into account. I want to underline another chapter that we often forget: private companies that offer services of general interest. Some of us, we have the competence to control them. Some of us, no. But those companies, besides the dimension of consumers, bills and quality, they are also citizens, and they have a right to access to basic supplies. And that, years ago, was something in the hands of the government of the states. Now is with no control, and we must take advantage of this and develop competence in the ombudsmanship to really take care that artificial intelligence does not relieve public authorities of the task of guaranteeing the rights of consumers, especially of those considered vulnerable. Remember what is happening with basic supplies in Europe in the present situation. I don't want to discuss who is responsible, but it's happening and harming a lot of rights. I will conclude in a very fast and easy way. We need to regulate people's rights in front of possible abuses of artificial intelligence. European legislation on the protection of personal data is a good point of reference for dealing with this regulation. Specific measures need to be proposed so that artificial intelligence technologies and applications become tools in the struggle to eradicate gender stereotypes. Artificial intelligence systems must be used as a tool to reduce gender inequality and other types of inequality. Artificial intelligence imposes additional technological effort on administration to ensure the protection of consumers, and artificial intelligence obliges to increase information to consumers about the risk or irregularity in the contracting of goods and services. I congratulate the Greek Ombudsman to introduce this subject in this conference, and I ask to the board, and as you know, in a very few weeks, I won't be a member to ask you for anything. I ask to the board to continue the Tallinn, Riga, Eno, now Sunion, Athens tradition dedicated to us. And I want to thank that, Andreas, on all your splendid Sinigoros team. Remember, all of us, that yesterday we were in a fantastic site that Homer in the Odyssea says, but, that's Homer, not me, eh? But as we rounded Holy Sunion, Athens headland, Lord Apollo attacked Atrides, helmsman A. And there is a Catalan poet that translated Odyssey and wrote a poem on Sunion, and it's my special dedication to Sinigoros, to Andrea, just a brief part of the poem. Sunion, from afar I'll evoke you with a cry of joy. You and your constant son, king of sea and wind, beside your perfect marble, as noble and ancient as it. Thank you very much.
Thank you very much for highlighting these challenges, and I believe we will highlighting them every time we meet, because it is very interesting topic, and it touches every time. And I wish you a very nice flight.
Thank you.
And see you soon.
Sorry to everybody. Thank you. Bye.
So our next intervention comes from Belgium. I would like to ask dear colleagues Jérôme Os and David Balle to present their intervention. Thank you.
Thank you, Mr. Zvetina, for the introduction. And thank you, Mr. President and the board of the IOI for the invitation to intervene at the conference today for the IOI. Si vous permettez, on va continuer en français, puisque notamment j'ai déjà entendu que les interprètes font un excellent travail. Donc voilà, bonjour chers collègues. Quand on parle de l'usage de nouvelles technologies dans les services publics, on en vient inévitablement et directement à la transformation numérique. Et c'est un sujet que nous avons abordé à plusieurs reprises récemment, encore la semaine passée lors d'un congrès de l'AOMF et encore au mois d'avril lors d'une conférence de l'ENO. Mais cela reste absolument un sujet d'actualité car la numérisation a un impact majeur sur les relations entre les citoyens et les administrations. Et cet après-midi, mon collègue Jérôme et moi ont l'honneur de partager en bref notre expérience et notre point de vue avec vous. Et d'abord, on va aborder, comme vous voyez d'ailleurs sur le slide, la digitalisation. Nous aborderons ensuite l'application de l'intelligence artificielle dans les services publics et enfin, nous parlerons du concept de nudging. Alors, depuis sa création en 1995, le médiateur fédéral de Belgique s'efforce de contribuer à une meilleure accessibilité, une plus grande convivialité, davantage d'ouverture de l'administration et au renforcement de la confiance et de la compréhension du citoyen envers l'administration. Et 25 ans plus tard, les administrations ont fondamentalement changé et la digitalisation n'est pas étrangère à cette évolution. Les processus sont informatisés et les moyens modernes de communication sont de plus en plus utilisés. De nouvelles technologies et de nouvelles techniques comme le nudging et l'intelligence artificielle gagnent du terrain. Alors, l'innovation est une chose sérieuse qui exige du temps et de la détermination. En Belgique, nous explorons diverses nouvelles technologies, en particulier les technologies mobiles, l'intelligence artificielle et l'innovation fondée sur les données. Et je vais vous donner quelques exemples de ces techniques et technologies au sein des administrations belges. Et en même temps, j'aborderai les nouveaux défis pour les médiateurs et les ombudsmans. Alors, premier exemple, dans le domaine de la sécurité sociale, pour améliorer les services et pour qu'ils soient plus efficients, plus rapides et plus faciles à utiliser, les institutions publiques de sécurité sociale en Belgique ont défini une stratégie commune en matière de numérisation et d'automatisation. C'est en 2018 que la sécurité sociale a commencé à entrer dans le monde formidable de l'intelligence artificielle. Et plusieurs initiatives ont été lancées à titre expérimental. Par exemple, l'utilisation d'un robot d'accueil, l'installation d'un agent conversationnel ou chatbot et le recours à l'automatisation robotique des processus ou la RPA, Robotic Process Automation. Et la RPA vise notamment l'automatisation des tâches répétitives et sa finalité est de permettre aux travailleurs d'avoir plus de temps pour se concentrer sur des actions à valeur ajoutée. Donc, elle est une technologie permettant d'automatiser des processus métiers qui nécessitaient jusqu'à là de l'intervention d'un humain. Donc, elle était capable de traiter des tâches répétitives et chronophages grâce à l'utilisation de logiciels d'intelligence artificielle ou du machine learning capables d'imiter un travailleur humain. Alors, comment fonctionne cette technologie? Imaginez un robot numérique se connectant au système et utilisant l'interface utilisateur graphique exactement comme le ferait un humain, mais à des vitesses fulgurantes, sans erreur et sans avoir besoin de pause. Donc voilà, comme ça, vous avez en bref déjà une idée comment, ou de la façon plutôt dont un logiciel de RPA fonctionne. Alors les ressaisies, les copier-coller des données d'une application à l'autre, la comparaison des données, toutes ces tâches habituellement faites par des humains de façon répétitive deviennent désormais automatiques. Un autre exemple dans le domaine de la fiscalité, ce sont les critères de sélection de contrôle via le data mining pour déterminer auprès de quels indépendants ou quelles entreprises le fisc va contrôler le respect des obligations fiscales. Et il établit sur la base d'un algorithme qui permet, en rassemblant de l'information dans les diverses bases de données fiscales, ce qu'on appelle le data mining, d'établir des profils à risque et ou des actions de contrôle spécifiques. Maintenant, qu'est-ce que c'est spécifiquement le data mining? Donc, selon la définition qu'on choisit, il s'agit ou non d'une forme d'intelligence artificielle, et la Commission européenne définit l'intelligence artificielle comme la capacité d'un programme informatique à effectuer des tâches accomplies par des humains demandant un apprentissage, une organisation de la mémoire ou un raisonnement. Et j'ignore si le système du fisc est capable d'apprendre, mais si c'est le cas, il s'agit d'une forme d'intelligence artificielle, sinon cela dépend de la définition qu'on utilise de l'intelligence artificielle. Alors, quels sont les avantages et les désavantages pour les citoyens et pour les administrations? Les avantages pour les citoyens sont les suivants. Il y a moins de risques de partialité, d'impression de partialité, et le contrôle ne fait pas suite à une décision d'un agent, sur base de critères parfois flous ou arbitraires, mais de profils de risque ou d'action de contrôle spécifiques. Les avantages pour l'administration sont que la gestion par data mining permet de mieux cibler les contrôles fiscaux à partir de profils de risque et de rendre donc les contrôles plus efficaces. Et l'utilisation du data mining permet en partie de compenser la diminution des effectifs au sein de l'administration fiscale. Alors, les désavantages pour les citoyens, certains citoyens sont identifiés comme profils à risque alors qu'ils ne sont pas spécialement, ce qui peut mener à des contrôles fiscaux à répétition ou à des impositions non justifiées. Et finalement, quels sont les désavantages pour l'administration? Le recours au data mining pour sélectionner des profils de risque peut avoir pour conséquence de passer à côté de certaines pratiques de fraude fiscale. Il peut être possible pour certains citoyens ou entreprises, généralement aidés par des conseils fiscaux, d'anticiper des profils de risque du data mining et d'adapter le niveau méthode de fraude fiscale afin de ne pas être associé à un profil à risque. Et auparavant, le risque de faire l'objet d'un contrôle fiscal aléatoire était beaucoup plus important puisque chaque entreprise risquait de manière régulière de faire l'objet d'un contrôle fiscal. Alors, c'est avec plaisir que je donne maintenant la parole à mon collègue Jérôme,
Merci.
qui va aborder...
Un troisième exemple de nouvelles technologies que certains départements de l'administration fédérale belge utilisent. Il s'agit de My e-Box. My e-Box est en fait une interface sécurisée qui permet de recevoir, consulter et gérer des messages, des courriers adressés par tous les services publics de l'administration fédérale belge qui participent à ce programme, des messages reçus donc ou transmis par voie électronique dans votre e-box personnel. Cette e-box personnelle, mais cela ressemble très très fort à votre mailbox de Gmail ou d'autres providers. En donnant votre autorisation, vous consentez donc à ce que l'administration fédérale belge vous envoie des courriers. Vous vous engagez à lire ces courriers et vous ne recevrez plus ces courriers sous forme papier, sachant que les effets des courriers que vous recevez dans votre e-box sont les mêmes que si vous aviez reçu le document par la poste, donc sous format papier. Quel problème avons-nous constaté? En fait, un certain nombre de citoyens ont activé leur e-box sans le savoir, par accident, ou sans percevoir correctement quelles étaient les conséquences de l'activation de cette e-box en arrière. Par exemple, lorsqu'ils ont demandé à recevoir un certificat de vaccination dans le cadre de la pandémie, ils ont activé leur e-box, mais sans se rendre compte que, par là même, le SP Finance, donc l'administration qui établit d'abord et puis perçoit l'impôt, allait en tirer comme conséquence que vous ne souhaitiez plus recevoir votre feuille d'impôt par la poste, mais bien au moyen ou dans votre e-box. Le problème, c'est que ces personnes n'ont plus été consultées, leur e-box, elles ont peut-être même changé d'adresse mail et n'ont pas pris connaissance, par exemple, d'une invitation à payer leur impôt. Vous en concluez les autres problèmes qu'il faut se poser. amendes pour non-paiement de l'impôt, parfois même mesures d'exécution forcée, et j'en passe, comme très important également, expiration du délai de recours contre l'impôt qui a été calculé. Alors, nous avons pris contact avec les administrations qui sont impliquées dans certains de ces programmes pour leur dire qu'il était particulièrement important de communiquer davantage pour mieux informer qu'auparavant les citoyens de l'existence de cette e-box, des conséquences de son activation et de la possibilité de désactiver l'e-box pour ceux qui le souhaitaient. Mon quatrième point concerne le nudging. Il ne s'agit pas à proprement parler d'une technologie, mais plutôt d'une nouvelle technique que certains départements de l'administration fédérale belge utilisent. Qu'est-ce que le nudging? Mais c'est un concept issu des sciences du comportement qui fait valoir que des suggestions indirectes peuvent, sans forcer, influencer les motivations et inciter à la prise de décision, et ce de manière tout aussi efficace qu'un ordre ou une disposition légale. De telles suggestions sont souvent utilisées dans le cadre du marketing pour influencer un comportement d'achat et conduire même à l'acte d'achat lui-même. En Belgique, cette technique est utilisée entre autres dans deux secteurs de l'administration fédérale. D'une part, le secteur de la sécurité sociale et d'autre part, le secteur de la fiscalité. Premier exemple, l'administration qui octroie des allocations aux personnes handicapées a constaté que plusieurs personnes handicapées ne se rendaient pas au rendez-vous qui avait été fixé, rendez-vous qui avait pour but d'évaluer l'impact de leur handicap dans leur vie quotidienne. Cette évaluation est nécessaire pour pouvoir reconnaître le droit à une allocation allouée aux personnes handicapées. Alors, problème, si vous ne vous rendez pas à votre rendez-vous, conséquence, retard dans la reconnaissance du handicap, retard dans le versement de l'allocation. Mais pour l'administration, cela pose aussi des problèmes parce que des personnes qui ne se rendent pas à des rendez-vous, c'est autant de perte de temps, autant de perte d'efficacité et même d'argent. L'administration a dès lors pris contact avec un certain nombre de personnes qui ne s'étaient pas rendues à ces rendez-vous pour comprendre les raisons pour lesquelles elles ne s'y étaient pas rendues. Elle a constaté qu'il y avait en fait pour elle un manque d'information ou de compréhension concernant l'utilité et l'importance de se rendre à ce rendez-vous. L'administration a alors rédigé une nouvelle lettre de convocation, une brochure d'information et également des modèles de SMS de rappel. Les effets ont été positifs assez rapidement. Les personnes handicapées se rendent beaucoup plus souvent qu'auparavant à leur rendez-vous. Et pour l'administration, il y a eu un gain en termes d'efficacité, puisqu'on a évalué qu'entre de 60 heures à plus de 90 heures de travail sur un échantillon de 1000 personnes qui avaient été invitées à se rendre à leur rendez-vous. Donc il y a eu un gain de 60 à 90 heures de travail. Deuxième exemple, en matière de fiscalité, l'administration qui est en charge du recouvrement de l'impôt a également fait application de la technique du nudging. Et là, pour essayer d'augmenter la rapidité avec laquelle les contribuables payent l'impôt ou inciter ceux qui ne le faisaient pas avant lettre de rappel ou menace d'exécution forcée à le faire. Elle a rédigé en fait 9 modèles de lettres comportant chacun un nudge différent. Elle s'est rendue compte qu'en fait, un modèle de lettre, celui qui mentionnait les conséquences financières en cas de non-paiement aboutissait à plus de 21% de paiement dans les temps, dans les délais. Et donc, c'est avec voilà, un certain succès que cette technique a été utilisée en la matière. Alors, avant d'en venir à notre conclusion, comment nous situons-nous, David et moi, par rapport à l'utilisation de ces nouvelles technologies et techniques par l'administration fédérale belge? Et plus généralement, comment réagissons-nous par rapport à la numérisation, la digitalisation de l'administration fédérale belge? Mais nous savons tous que derrière chaque contact entre un citoyen et une administration, il y a un processus. Nous constatons tous qu'aujourd'hui, ces processus sont de plus en plus numériques. Cela présente, comme David et moi venons de le dire, des avantages, mais également des inconvénients. En effet, il y a en Belgique une fracture numérique. 7% de la population je parle de la population active de 16 ans à 74 ans, 74 ans, n'a jamais utilisé Internet. 10% de la population n'a pas de connexion à domicile. Seuls 59% de la population active utilise Internet pour communiquer avec l'administration en ligne. Alors, nous nous rendons bien compte qu'il faut prêter une attention toute particulière à ces personnes qui n'ont pas soit les moyens, soit les connaissances numériques suffisantes pour pouvoir dialoguer avec l'administration en ligne. Et nous avons donc une double approche par rapport à ce constat. D'une part, au premier volet de cette approche, nous avons recommandé au Parlement fédéral belge de reconnaître l'accès à Internet comme étant un besoin essentiel. Aujourd'hui, l'accès à Internet, c'est l'accès à l'information, même si elle est parfois sujette à doute. Accès à l'information, aussi un moyen de jouir et d'exercer de ses droits, et parfois des droits très importants. Dans certains pays, on peut voter par Internet. Et donc, nous avons recommandé à l'administration d'en faire un droit fondamental et de l'inscrire dans la Constitution, sous la partie qui reconnaît aux citoyens, enfin aux Belges, un certain nombre de droits socio-économiques et prévoit que tout un chacun a droit à une vie conforme à la dignité humaine. Cette recommandation est actuellement à l'examen au sein du Parlement. Deuxième volet de notre approche, et qui est indissociable, pourrais-je dire, du premier, c'est que, afin de réduire cette fracture numérique, nous insistons pour que l'administration fédérale prévoie des aménagements, prévoit toujours une alternative à la communication digitale avec elle, et pour qu'il y ait toujours, pour les citoyens qui en expriment le besoin, la possibilité d'avoir avec leur administration un contact direct et humain. C'est pour nous essentiel. Un ordinateur ne peut en effet pas faire preuve d'empathie, en tout cas pas encore. Nous vous remercions de votre attention.
Thank you very much for sharing with us also your experience, your daily experience with these two challenges. And now I would like to invite Ms. Julia Dalvik from University of Applied Sciences in Vienna to have her intervention, please.
Yes. Okay, I would need the pointer, please. Thank you. So I think the presentation will be started. Okay, perfect. Thank you very much. So thank you for the introduction and the invitation to be here. I'm very honored and pleased to be able to speak to you today and to be a part of this conference. I was invited to present some of my preliminary findings from an empirical study that I did earlier this year, and actually I'm still in the middle of analyzing the data. So as I said, it will be only preliminary findings, and I hope to have a report ready in autumn or end of this year. Also, I want to say that this is, in terms of funding, it's a very small-scale project. It's funded by my university. So it was my own initiative, and I'm very grateful for the support of the IOI for sending out the survey and supporting this research. And yeah, so what I also want to add more before I start is that it was an explorative study. There is very little social science research on ombuds institutions. As you all know, there is more on the legal perspectives on ombuds institutions. So this is why I tried to break some ground on ombuds work and digitalization. And I hope to be able to continue this in the future. So what is my starting point actually for the study? Coming from Department of Public Administration, Public Management at the University of Applied Sciences. So I was originally looking at sociological perspectives on public administration. So what I was interested in was the digital transformation in the public sector at large, so to say. And in the scientific literature, there has already been stated several times that there is a need for social science research into the use of new technology in the public and also in the justice sector, actually. So the question that I'm interested in more generally is how is the relationship between citizens and the state transformed through digitalization? And more specifically, how is access to justice affected, and are there any potential unequal outcomes for citizens? Of course, we know that digitalization has a lot of positive effects, and it's very often stressed very much, the positive effects, such as easier access to justice for certain parts of the population. We tend to forget that it's not typically the whole population. Digitalization can serve as an equalizer, so as a more just treatment also. It can be used as an anti-corruption tool also, so there are many aspects that are pro-digitalization, I would say. But as a sociologist, I would like to take a more critical perspective to the techno-optimistic view on digitalization and focus a little bit more on the role that digitalization can play in reinforcing existing inequality, because we know that there is already inequality in access to justice and public services. Yeah, I'm sure you're all familiar with the terms of e-exclusion, digital divide, and so on. So it's known that the population actually throughout the world has very different possibilities of accessing digital tools, digital means. And it's not only, it was mentioned today already a few times, it's not only individual capacities, it's not only digital literacy, but I think it's quite clear that it's also about structural, infrastructural aspects. We already heard about broadband, right to broadband access, and so on. So I think we always have to be aware that it's individual and structural aspects that we need to consider. So why am I looking at ombuds institutions? Yeah, public ombuds institutions are, of course, the key control mechanisms, and as such, they are, in my opinion, an ideal observation post for the problems that citizens encounter with public services, digitalized public services. And at the same time, of course, they're also public service providers, and they are doing this in a digital way. So that's why I think that those institutions are really interesting in different ways. And also one could suggest that ombuds institutions should be role models for the public administration in providing digital services. So going ahead with best practice. As I said, I'm focusing on effects of digitalization on ombuds work, on accessibility of ombuds services, and also the interaction with citizens. So I mentioned that it's an explorative study, and it's also quite a broad study. So I didn't want to focus on one specific aspect of digitalization, but really to try and cover a broad ground from the beginning, so then to see where to go on with further work. And in the literature, for example, we find that there is a risk that with implementation of online communication, so-called street-level bureaucracies, I'm sure you all know, this means that this is actually the face-to-face contact with the citizens in a public encounter, that they will develop to screen level, so which is already happening, of course, and then also to system-level bureaucracies, so more into artificial intelligence, so that also ITC information and communication technology will have a more increasingly intervening role, actually. So not only supportive, but really actually decisive roles. One of my particular interests was also the role of face-to-face interaction, because I think when we look at digitalization, we always also need to look at the same time at non-digitalization. So it's always two sides of the coin. And especially the consequences of these developments for access to justice and access to administrative justice. Yeah. Okay. What did I do? Actually, in this scope, I would like also to take the opportunity to thank all of you, all of those of you who have participated in the survey and in the research, also with the interviews. I got 79 complete responses on my survey that was sent out among all IOI members. So that's a response rate of 35%, which is not too bad, but could always be better, of course. I'm doing descriptive analysis and correlations, and as those of you who have participated know, I was focusing on the one hand on digitalization. I know this is a very broad term, so you're probably asking yourself, what does she mean by digitalization? I didn't provide a definition of the digitalization because I wanted more or less to have the research participants define what they think about when they think about digitalization. You have to think that I'm covering countries all over the world. So digitalization means something different in Kenya than it means in Peru or than it means in South Korea. And that's also something that I want to do with this research, going away from the Eurocentric perspective. I know this is a Europe IOI conference, but most of the research that is there, also even the small research that is there, is typically focusing on the global north. So we don't have much information, data on how things are going in the global south. So this is also one thing that I want to do with this research. And then really try to cover the different phases and stages that countries are in the process of digitalization. So I think we should be careful with assuming that it's everywhere like it's in Europe. And I know we're not doing this, but sometimes in our discussions we seem to forget. So I was also interested in the effects of COVID, of the pandemic, on ombuds work and digitalization. And not surprisingly, I found that that COVID was a driver, of course, also in ombuds institutions for development. And I did also do qualitative interviews with 42 IOI member institutions. They were all conducted via Zoom. I was also looking at what are the differences between digital and non-digital forms of contact with the citizens, what are outreach measures, what are also the problems that complainants face with digitalized public services. And additionally, I did an analysis of all IOI members' websites, looking at it from a user perspective, so pretending I was an ombuds user. Looking at the accessibility, at contact possibilities, how can I as a citizen contact the ombuds institution, looking also at the languages that the websites are provided in, number of branches, opening hours, and use of social media. So those were the things that I was interested in. I know it's taking a long time until I'm coming to the findings, but I think it's important to have this background knowledge also on the study. This is for you. I hope you can see it more or less to get an impression about the representativity of the study, because of course I didn't have an influence in who participates really. The IOI sent out a reminder, but I was of course depending on all IOI members' participation. But interestingly, the representativity is actually quite good, so quite similar to the distribution that it is according to the IOI world regions, according to the members of the IOI. And the same is true for the differentiation between federal national bodies on the one hand and regional local bodies on the other hand. So that was also quite okay, I would say, with regard to the distribution and regarding distribution in the IOI memberships. This is also for you to know which institutions, more or less, I was speaking to, or how this is distributed. Of course, the countries, the participating, or the member countries, the numbers of member countries in the IOI also differ according to the world region. So Europe is quite overrepresented with 17 institutions, and then Africa 8 institutions, Asia 3, Australasia and Pacific 4, Caribbean and Latin America 5, and North America 5. And I have to say that there are currently 12 more additional expressions of interest, and I'm very happy to conduct more interviews because it's very interesting to get information from different contexts of the world. I'm probably going quite fast, but yeah, I have limited time and I want to share a few things with you, but I would like to say that this is more of a teaser, so I would like to see this as a teaser for the findings report that will come out hopefully end of this year, so that you can get a brief impression on what I'm doing and what you can expect. So the first aspect is concerning the diversity of countries, diversity of contexts, and what I already mentioned, what does digitalization mean in the different countries. So this is something that I'm not going into detail here, but I just want to share with you that I organized or categorized the countries and compared the countries also according to their area size, population size, but also Gini index as the inequality index, GDP per capita, democracy index, world justice index, human development index, and an NRI overall score. So that's a development of digitalization in the respective country. And there you can see, if you can see it, that the range is quite big. So this makes, of course, comparison very hard, but I think that's normal if you compare countries throughout the entire globe. But it's interesting then to see, I'm not going to explain this, table right here now, but it's just to show you that there are some correlations between the indexes on development and inequality with regard to some of the variables in my survey. So I will say more on that in the report then. It's too much just right now. A few words on digitalization, its development and challenges in Ombuds work. I'm sure that's nothing new to you. It's just a kind of an empirical proof of what you're living day to day in your work, I guess. I was asking about the development of digitalization in your institution. And what I found interesting here is, so I aggregated the data here, only those who agree very much or agree much to that their work was digitalized in the past. So last 5 years, that's not a very long past, of course, but digitalization is going so fast. Present, which was during the pandemic, and then the future, near future in the survey. And I think it's interesting to see that during the pandemic, the increase, so the question was outside, the first question was without COVID, and then the second question was only during the COVID pandemic. And it's not surprising, but I think it's interesting to see that over 70% of all institutions agree very much or much that their work has digitalized further during the pandemic, and also approximately almost 70% think that that will also happen in the future. So we see it's a long and a big development, of course. But what I want to say also, actually we would have to look at the persons who don't agree and the institutions who don't agree. So it would be very interesting to see why do institutions say that their work was not digitalized in the past, in the present, or in the future. But unfortunately, surveys don't help us with why questions typically, so we have to do more qualitative research. I also show you the numbers for Europe specifically, and maybe here the most interesting finding is that compared to the overall world responses, there was more digitalization in the past in Europe, in the European ombuds institutions, which is maybe also not surprising, but interesting to see, I guess. What's also interesting, I think, is how digitalization is perceived, and it's perceived as primarily positive by 85% of all participants worldwide, and almost half of the participants think it's problematic. So it's not an either-or, as you can see, it's both. And the rates for Europe are very similar to the overall findings. So I think it's interesting to see that still almost half of all institutions think it's also a problematic development. I tried to show here the distribution among the world regions, and we see that, for instance, in Europe, that's the absolute numbers in this case, 12 institutions agree or strongly agree that digitalization is problematic. But there is also quite a lot, so there are 10 institutions out of the 30 that participated in this question that are not sure, or they didn't really decide if it's problematic or not. And then there are even 8 institutions that disagree, so they think that it's not problematic at all. And I think this is a very interesting answer because we will see later on. I asked also for whom is it actually a challenge, digitalization of public services? And there is quite a clear trend, which is also interesting, I think, that almost 70% of all institutions say that it's mainly the citizens that this is a challenge for, but then also the public sector in general, and only a little bit more than 40% think that it's a challenge for their own institution. So there is quite a clear hierarchy in this regard. And the numbers, again, for Europe are quite similar regarding the hierarchy, I would say. Coming to my third and last thematic point, I hope I still have some minutes. I just want to show you what I've got, or part of what I've got, and I will be happy to discuss more about it later. This is from my analysis of all the IOI members' websites, where I was trying to figure out how can I, as a citizen, access the Ombuds institution. And interestingly, this would probably not relate completely with survey findings, maybe because I didn't find certain things on the websites and so on. So it's really my perception of the website as a user. And we see, for example, here Europe is the dark blue color. So Europe is actually, the European institutions have almost all of these possibilities in very high, to a very high extent, compared to other to institutions from other world regions, for example, Africa or Caribbean and Latin America. Other explicit means that, for example, it's explicitly stated that you can write a letter to the Ombuds, so as an example. Then we also see that the use of contact forms is smaller. So I differentiated between complaint forms and contact forms. Some institutions have both. And then what I find particularly interesting is the thing about opening hours. So there are quite a lot of websites in different areas of the world that say more or less that you can come to the Ombuds institution, but there are no opening hours. So it's just maybe seems like a minor detail, but I think it's not. Another finding on accessibility, and you might ask the question, why are languages related to digitalization? But I think language is like the key, the most basic way of, most basic element of communication, right? Also between citizens and the state. So I also looked at which languages are, or how many languages are websites available in. And then we see here, just as an interpretation of the graph, you see, for example, that I think 34 institutions, European institutions, have their languages, have their websites in 2 languages. And the highest number, I'm not sure which institution it's exactly, but it's one in North America that has its website in over 40 languages. So I think this is also an interesting finding in terms of accessibility. Okay, I'm skipping this because it's too much. What I find interesting, because I said I always look also at non-digitalization, and I was interested particularly in face-to-face interaction, and that's something I found interesting. I was asking, please rank the contact forms with which you have the best experience regarding quality, and it's quite small, but it's 47% of all participants ranked the personal encounter as the one with the highest quality. And then, quite interesting, actually, the online complaint form was ranked first, second, and third around 15 to 20%. So the online complaint form is playing quite a big role and probably playing a bigger role in the future. Yeah, that's again European institutions, and it's quite similar to the overall rank. And also, because asking about digitalization and non-digitalization, I asked about the outreach measures' effectiveness according to the survey participants. And again, here, the appearances in traditional media ranked highest, or were mostly selected for the first rank. So it was not social media, for example, which is also gaining more importance. It's similar to the online complaint form that we just saw previously. It's the same for social media here, so it's ranked with 20% in rank 1, 2, and 3, so it's also gaining importance. But still, traditional media play an important role. Okay, I will skip this because I think running out of time, I will be happy to answer more questions. What are some preliminary findings, or yeah, to sum up quite briefly? The difficulty I already mentioned to compare what is meant by digitalization and which phase or which stage are different institutions currently in, especially when I'm touching a new topic now that was already mentioned previously, concerning artificial intelligence and algorithms, for instance. So it's a topic that's being talked about more and more, of course, in Europe and in the global north. But I think it's clear to everyone that artificial intelligence is not the key problem in countries where a large majority of people cannot even afford to access the internet, because internet is expensive, and where yeah, digitalization in ombuds work does not play this strong role yet as it does in Europe and in the global north. So we have to have this differentiation. Where are we? Where are we going? And even in the interviews that I conducted, artificial intelligence and algorithms did not play an important role yet. So most interviewees said, well, it's an upcoming topic, but it seemed that many of the interviewees were not quite aware, or at least they didn't tell me what is the status of use of algorithms and artificial intelligence in the public sector in their country. So it might be that it's not that transparent what is actually going on. And then, of course, one finding, it was also mentioned today already, that in order, I think it was colleague Ribo who said that also in order to be able to control the public administration, of course, the ombuds has to have the relevant competences and the competent staff to be able to do that and to know what is going on and to make recommendations and so on. So I think this is a topic for the future, and I hope that I will be able to do some follow-up studies in this area. And I'm looking forward to your questions and comments. Thank you very much.
Thank you very much for a very interesting intervention. Now I'm opening the floor for questions, opinions, your experience, good practices, bad practices, or let's say less good practices. Yeah.
I maybe have one brief question for Ms. Dalvik. I noticed that in one of your statistical findings that apparently citizens find a way to the public authorities by email, by writing an email, but not by filling out an online form. Did you find specific reasons for that in your study, in your analysis?
Thank you. Not yet, because, yeah, as I said, limited resources, and it's a first explorative study, but there are so many venues that I want to explore in more detail, and this is definitely one of them. So a lot of the why questions are not answered yet. But thank you.
No one? So, oh, yeah, please, Reni.
Well, thank you very much for your presentation of what you're going to do. Looking forward what's happening next autumn, and I will be curious to see what your next step in your research is. It's very interesting, and also a good combination with the introduction made by our colleagues from Belgium, because there is lots of links between the two, I think. I remember my office in 2017 also on this topic wrote already something on the e-box, as you call it. It's called in Dutch, mijn overheid, my governance dot something or e-something, whatever it is. What we came across, and probably you find it also in the research, or the colleagues saw the same in Belgium, is that there is a combination of people even not able to reach us in a normal, ordinary way, but certainly not in the way well, the new technologies make possible and feasible, and I'm still struggling on how to do that. We have the whole afternoon for outreach, I know, but still there is probably something specific in this way of communications that is now new, that you could already give some idea on what should we do as offices to be prepared for the future and your final report, of course. And that's one question, but probably more specific. In your research, this is a sort of mirror we give you on who we are today. So this is not what we want to be. Have you any idea where we would like to go to in the near future as ombuds institutions? Is it also in your research? So thank you.
Thank you very much. Difficult questions. So the first question, of course, what should we do to reach the people? Yeah, as you said, and it's actually known from the literature that already there is quite some inequality in who is accessing the Ombuds institution, and of course there is the potential that the gap is not going to be closed with digitalization. And as you already said, your institution, and I think many or most institutions already have quite a lot of different outreach strategies. And I think one of the key problems is that, at least from my impression, people don't know that there is the Ombuds. They don't know what the Ombuds does, and they don't know that they have these rights. So it's quite a basic question of legal consciousness, I think, and developing this legal consciousness. And I think it's one of the answers that is given to most questions, or many questions. It's necessary to start in school with this building of legal consciousness and explaining what all the institutions can do and should do, and when you can go to this institution, actually. But then we also have, it was mentioned yesterday, or also today, about the migrants, for example. So it doesn't matter if you teach that in school. When they come to a European country, they haven't probably heard about the institution. So yeah, as a sociologist, I can make a diagnosis, I can do some suggestions, but unfortunately, yeah, I don't think that there is the one perfect solution. But as you say, I completely agree that it's necessary to have a broad variety of opportunities, and I think it's also important to go to public space, go to the communities, go to the schools, and that's what many institutions do already. And otherwise, yeah, it's a difficult question. And the other question was somehow what the ombuds should be like in the future. That's also a good question. Yeah, I think it's also one of the questions concerns the different mandates that so many ombuds institutions have. So is there a limit to the mandates that an institution can have or should have? Does it need another new institution that covers all that? Or so I think this is one question that could be interesting, and how this develops in different parts of the world. But there are many questions. Thank you. More questions than answers.
Thank you. Yeah, please, call from Sweden.
Is it on now? Yeah. Yeah, Peter and I, we were talking on the bus this morning about different challenges. concerning digitalization. And in Sweden nowadays, there's a huge discussion going on because of the failure from the authorities. It's like, it seems like it has come as a surprise for the authorities that after 2 years of pandemic, people actually wants to travel and wants to have new passports. And, and that's a digitalized system. So you have to book your time online. And there's been quite many individuals that started to book many, many times and sell them second-hand, so to say. So the queues now are enormous. You have to wait for 3 or 4 months to get a new passport. But at the same time, there's a lot of these times that have been booked that there are no people coming up there. So the authorities are sitting, no clients, and an enormous queue. So that's just an example of the difficulties with using digitalization. And that is in a country that we believe, we people in Sweden, we believe that we are quite high qualified in this area, but it didn't work this time. So there's not going to be a lot of Swedish tourists around the world this summer.
Thank you very much for this intervention. Yes, please. Colleague from Andalusia.
Muchas gracias. Yo represento, soy defensor de Andalucía, de España. Y llevamos ya mucho tiempo en esto y me parece que el tema es muy interesante. Me parece que estamos en los comienzos ahora de las consecuencias de la pandemia y en el informe nuestro decíamos que había retos y pusimos 13 retos. Yo me voy a referirme a 2. En el Congreso de Estrasburgo hace poco se decía que los defensores estamos mirando para adelante los algoritmos y ahora una gran empresa, Endesa, en España, me va a regalar ahora elementos y algoritmos de inteligencia artificial. Y cuando yo con mi equipo informático me presento esto, como defensor sí tenemos ya, claro, muchas cosas que tenemos que hacer. Y es que nosotros, referente a la inteligencia artificial, tenemos que mirar a la cola, porque hay inmensa gente en la cola. Estamos viendo que vamos a hablarle a una máquina, que vamos a hablarle a un robot, que la presencialidad se va a acabar. Pero eso va a matar a mucha gente. Y ahí entran los grupos vulnerables, entran los barrios deprimidos. Yo he vivido en 2 grandes, el famoso de Sevilla, de las 3.000 viviendas. Y me pregunto ahí, ¿esa gente qué va a hacer? No puede, eso unido a la administración electrónica, tenemos muchas quejas que están quitando posiciones porque el programa no entra bien y al final se quedó sin firmar. La pregunta clave de la gente en la pandemia, que hicimos 10.000 quejas nuevas, fueron: ¿a mí quién me atiende? ¿Quién me coge el teléfono? ¿A dónde voy? Y algunos decían, monoparental y con hijos, esta noche estoy confinada y no tengo comida. Yo creo que ahí los defensores, evidentemente no vamos a parar la inteligencia artificial y va a seguir adelante, pero va a crear muchísimas heridas y dualiza la población, desiguala la población. Y en los derechos humanos los defensores ahí tenemos que ir a por la igualdad. Y esto ha creado un ejército de excluidos. Se llama los nuevos excluidos, la brecha digital, porque no hay conectividad, no hay medios, no hay recursos. Respecto de los colegios, si no hubiera sido por la presencialidad que defendimos, se hubieran perdido 2 cursos. Necesitamos al mismo tiempo una administración al revés, porque en temas de salud la atención primaria se la comió el COVID. Las patologías quedaron atrás, las citas se olvidaron y el COVID invadió la atención primaria, las UCI y los hospitales. Ahora se está volviendo otra vez. Y ahora dice, ¿quién me coge una cita? Nadie coge una cita. Y si tiene para algo, lo citan para 15, 20 días. Por eso uno de los retos decimos, tenemos que obligar a que haya una administración humanizada, una administración de cuidado, más que nunca. Después de la pandemia necesitamos una administración humanizada, de cuidados. ¿Por qué? Porque la cantidad de gente excluida es tremenda. Nosotros ahora mismo, yo estoy actuando ahora con 30.000 actuaciones de recuperación de derechos, porque tengo 8,5 millones de gente. Y eso me preocupa muchísimo. Y ahí los defensores sabemos muchas cosas que tenemos que hacer. Yo no me quejaría tanto de competencia, ni incluso con empresas de interés general, porque yo uso la intermediación, la supervisión y la mediación. Y llevo 350 quejas de mediación de conflictos gordos. Claro que sabemos algo, poco, yo sé poco de inteligencia artificial. Escucharé a ver ahora cómo se sustituyen los radiólogos por un robot y el certificado que ha hecho la Unión Europea de ir quitando radiólogos. Al final me voy a encontrar con una administración, digamos, no humanizada, nada presencial, no voy a ver al médico al ojo clínico, voy a ver a una máquina o algo así, y me tengo que relacionar sin saber, sin tener conectividad en los barrios. Yo me pregunto, la economía informal, ¿cómo vive o ha vivido en el confinamiento y cómo no tiene un ordenador ni conectividad ninguna? Las 50.000 personas del barrio donde yo estaba no tiene nada de eso, había uno en la universidad. Esa gente tiene un apartheid digital. Y nosotros, a mí me gustó lo de Estrasburgo, de hoy. Vamos a mirar para atrás, porque ahí la cola es inmensa, fragmentada y dualizada. Estamos haciendo en educación la Andalucía vaciada, y en octubre haremos todos los defensores de España a España vaciada. No hay movilidad, los mayores no tienen cuenta bancaria, no hay cajero, han desaparecido. Los bancos ya hacen gestiones de transferencia, pero no atiende a nadie y solamente hay algo de las 10 o las 11 que se puede ir a un banco. Toda esta gente acuden a nosotros. ¿Qué respuesta vamos a dar? Yo creo que tengo claro que hay muchas actuaciones que no hay que esperar. No sé lo que va a dar y no voy a parar la inteligencia artificial. Y sé que hay cosas que van a ser beneficiosas, lo decía uno de los ponentes. Pero como defensor del pueblo, miremos dónde está la población más desigual, dónde están los más vulnerables, porque ahí esos han perdido derechos. Y sin derechos esa gente vuelve a vivir todavía peor en un mundo que se dice que estamos ya en 5K, etcétera, etcétera. Esta es un poco, que no lo estoy haciendo como una acusación, porque me cito un poco, pero que creo que es bueno que alcemos la voz, porque ahí los defensores tenemos una gran labor y una gran respuesta de recuperación de derechos, porque nosotros nos distinguimos por recuperar derechos y no por aumentar todavía los derechos y olvidarlos. Muchas gracias.
Thank you.
Thank you very much. Thank you very much for a very interesting introduction to a topic we discuss a lot, but we don't always know the content so much when it comes to our work. So as ECRI in the Council of Europe, we are trying to see how it will affect our work on monitoring discrimination or possible discrimination through this machine learning or big data algorithms, facial recognition, etc., because we know it has this possible impact. I just wanted to add that in the Council of Europe, there is going to be, almost at the same time as in the European Union, a convention on artificial intelligence and human rights. So in the next 2 years, there is work on exactly these topics, how it will affect. And what we see is that we need to work with companies, with IT experts, at the phase of the designing of the different programs, and not at the phase when they are already launched. And we will have to see also how it will impact, because GDPR had a bad effect on a number of human rights issues. So on research we're trying to do, on data collection, everybody uses GDPR for reasons not to provide data. So we don't want to see this happening also with artificial intelligence. So we are trying to see how we will work with intellectual property rights, for example. This will be an issue we will have to look at. So thank you once again for your...
Thank you, and thank you for all participants in this debate. We are running out of time, so I would like to thank you all for these debates and the contributions, valuable inputs, and great exchange of views and ideas. I conclude this debate with final thought that in the area of digitalization, the use of new technologies, we must be focused on the users, on the people and their needs, because that is the only way to respect their dignity. The steps ahead are not the easiest, but rather full of challenges and opportunities. And I believe that everyone on our field will contribute to be a strong voice for all of those people which cannot raise voice for themselves. So thank you very much. And thank you, Mr. President, and your team for organizing this great event. Thank you. Now we have lunch break.
Would you like to take your seats, please, for the thrilling event which is now about to take place? Okay, well, welcome back after that fabulous lunch. Thank you, Mr. President. So, this is the last substantive session of the conference. And the first thing I need to say is that I am acting under orders from President Potakis that this session has to end at 10 to 4. Which gives us 52 minutes. And we will have a great time. But the South African liberation movement produced a man called Govan Mbeki, who was on Robben Island for 25 years. And he said, comrades, the first principle of the revolution is effective timekeeping. And we will keep time. And we have a stellar cast to speak to us, which is the good news. And the challenge for them is that they're going to have to put their important points to you inside 10 minutes each, so that we can have a proper question and answer session to finish off what's been a memorable conference. So, we will make sure you get the full content of their very carefully prepared speeches online, but please understand that we're put in this position by necessity, not by choice. So yesterday in the Manchester Memorandum, we committed ourselves to writing for IOI a best practice guidance on what it's like to reach out to people who don't normally come to our institutions and how to do it. And I have the honor to have 3 practitioners who are going to begin that story today. So we're lucky to have the ombudspersons from the State of Israel, from Hungary, and from the Netherlands. And you're very welcome, and thank you for joining us. So given the time constraints, can I invite Mr. Matanyahu Engelman, the State Controller and Ombudsman of Israel, to begin the conversation. I don't know whether you prefer to go there or you do it from here. Okay, thank you. Could you give him a warm welcome, please?
Okay. Dear Mr. Potakis, thank you very much for your warm hospitality. 2 meanings of warm, of course, yeah? But distinguished guest. I'm delighted to have the opportunity to speak to you at this interesting conference in order to present my perspective on the subject of reaching out to the people. It is common knowledge that the Ombudsman institution is assigned to assisting every person in protection of his or her rights and to helping him or her cope with the wheels of democracy, acting as a mouthpiece for the individual in his or her interaction with government authorities. Upon entering office, we laid down the vision for the role of the Ombudsman. The Office of the Ombudsman is an objective, professional, and accessible body for investigating complaints received from any person in order to uphold his or her rights and to advance effective and just public services for all sectors of society. Although the Office of the Ombudsman investigates the complaints of every person turning to it, it is obliged to take proactive measures to reach out to the public in general and to vulnerable communities in particular. While the Office of the Ombudsman takes measures to reach out all sectors of society, this presentation will lay emphasis on its action to reach out the communities that are worthy of special attention, those communities that experience particular difficulty exercising their rights and coping with government authorities. These vulnerable communities are required to contend with several obstacles and barriers on paths to exercising their rights, such as geographic barrier, the language barrier, the cultural barrier, and the financial barrier. Before I discuss these barriers, I would like to address an urgent issue that has taken to forefront in recent months. I refer, of course, to the sudden and severe refugees crisis generated by the war in the Ukraine. Over 27,000 new immigrants and refugees from the Ukraine have entered Israel, and I believe many of your countries too, since the outbreak of the war. The Office of the Ombudsman has taken and continues to take measures to reach out those refugees and to assist this newly created vulnerable community. In addition, the office has been handling the complaints of people who have fled the war in the Ukraine. An example of one such complaint is that an Israeli citizen who was living in the Ukraine with his Ukrainian wife, upon the recent birth of their son, the complaint filed an application with the Israeli consulate in Kiev to register the child as an Israeli citizen. He couldn't do it, and upon our interfering in dealing with his complaint, he could register his son and bring him to, unfortunately, due to the situation, to Israel. I will now briefly discuss the different barriers facing vulnerable communities and describe how the Ombudsman Office of Israel deals with each and every one of them. The first one is the geographical barrier. Many vulnerable communities reside in the geographical periphery, far away from the places where government ministries or other public bodies are concentrated. It is true that recently the digital services which we spoke about, provided by public service, including the Ombudsman Institute, have and previously gained momentum due to the COVID-19 pandemic. However, our experience teaches that people belonging to disadvantaged communities take less advantage of online services, recalling from digital means of communication, and still seek personal and direct contact with public servants and providers of services to help them exercise their rights. So for that reason, we have, beside our main offices in Jerusalem, Haifa, and Tel Aviv, we have branches for the Ombudsman offices in the periphery of Israel, and we have also launched a program that we call the Ombudsman in the Community, which we communicate with NGOs that are handling complaints and civil rights in Israel, and we obtain complaints with their location. We come there once a week, and we obtain complaints at their sites, going out of our offices in order to welcome and to let especially vulnerable communities sending us complaints. Another element we adopted is also receiving complaints via Zoom. I think that we all should adopt new method and be more accessible to, especially to all the communities, but especially to vulnerable communities. The second barrier is the language barrier. And over the years, many immigrants and refugees also came to Israel from all corners of the world. Some of them belong to communities that they don't speak the official language Hebrew. So for that reason, we supply our services in many languages, such as Hebrew, Arabic, French, Spanish, English, Ukrainian, Amharic, Russian, etc. And we recruit staff that speaks those various languages in order to assist the complaints. We also, and we will distribute it later on for you to see, we distribute our pamphlet and other reports also in different languages, mainly we do it in Hebrew, Arabic, and English, but also in other languages such as Russian, Czech, and Amharic, in order to let the people know that we can collect complaints in different languages. We also are focusing on, for example, we have a radio program that would participate on a weekly basis, but we picked the radio that is targeted for Russian speakers, immigrants to Israel, and there we present our work on a weekly basis. We have a 5 minutes or 10 minutes in this radio program in order to let the people know that we can receive complaints in different languages. The next barrier is, of course, the cultural barriers. And many times the cultural barriers, from my point of view, is much more important and much more difficult to be handled than the language barrier. Such as example, I will tell you about a man from the Bedouin community, an Arabic community, very poor, that lives in Israel, who complained that his application for a work grant was rejected by the tax authorities on the grounds that he owns real estate that did not serve residential purposes. And the reason was that he was living, I don't think it's a tent, but he was living in a very temporary building without a permit. But the tax authority told him, you are not allowed to receive a grant for people with very low income funds. And we found out, and we have ordered eventually the tax authorities to, even so he is living in a house without a permit, still it's not a real estate. It's a building that he lives there, it's his residence, and therefore you shouldn't harm him twice and not giving this grant. And once again, sometimes we believe that many of those communities are lacking basic trust in the government system, which we have to deal with and to let them cross with this cultural barrier. The last barrier I will speak about is the barrier of the financial barrier, because we know that service provided by the office, of course, all our officers are professional, effective, throughout complainant investigation, and what is most important, it's provided free of charge. The services constitutes a priceless solution to the financial barrier that might otherwise prevent vulnerable community from exercising its right. And there is also the issue of the bureaucratic barrier that can manifest in the multifarious interactions between persons claiming a benefit or service and the authorities. So we try to assist them, and for example, for this case, I would mention a woman who contended that the medical cannabis unit with the Ministry of Health was delaying handling her application to renew her license for medical cannabis. The investigation disclosed that the complainant has filed her application via an email address which was wrong, that has happened on the Ministry of Health website, and it was on the Ministry of Health website, but it was not suitable, of course, for sending the request. And the office informed the unit that it must publish its contact details clearly and visibly in order to prevent other patients from sending application and document to a wrong email. There is also the lack of knowledge barrier, and this barrier includes lack of knowledge about existing rights, its terms, and for example, we had a complaint from an Ethiopian old woman that came to us with a closed envelope of fines she received from the municipality. She didn't know even what's in the envelope and what is the reason. What is the reason she received this fine? And by assisting her and going with her about the fine that she received, we could have deal with her complaint and send a request for her municipality to assist her. part of it, and we do want to focus on some very important groups that I think that we all focus on. One of them is, it's spoken a lot, reaching out to older people. As part of it, at the last report I presented to the Parliament, at the same day we went to old age homes and explained them about the possibility to send or to complain through our offices. But I want to mention also, and you have it on your tables or we'll distribute it, we are also focusing on children. And as part of it, as you know, and I'm also the state controller of Israel, not only the ombudsman, so I can use many complaints to see if we are getting and going into the audit process and to publish a special report. So we decided, upon receiving many complaints of children and their parents, to publish a special report regarding the issue of protecting children online. So this is another topic that I think we should face all, looking at children of youth. To summary, I think we should look very carefully on the vulnerable community that we serve and pay special attention to let them know that we can receive complaints, we are there for them, and take many steps of reaching out to those population as part of our role. Thank you very much.
Thank you very much indeed, and apologies for putting you under pressure, but
No,
you
it's
handled
okay.
it. You handled it beautifully, and we'll want to come back to you with some questions. It's now my great pleasure to introduce someone I've not met before, the Commissioner for Fundamental Rights in Hungary, Akos Kozma. You're warmly welcome. The floor is yours, but again, 10 minutes, please.
Okay. Thank you very much, dear Chair, dear colleagues. Thank you very much for the opportunity to speak some words about the new regional offices system in Hungary. And I would like to tell you some sentences about the new offices at the Hungarian-Ukraine borderline, which is a very new institution from us. In the first line, I would like to tell you some previous events. As early as 2020, when the pandemic broke out, I decided that I wanted to be there in person in most places to monitor the situation. That is why I launched a series of country visits in spring 2020, which is still ongoing. As Ombudsman, I have now visited more than 100 institutions in the most unexpected places and the most unexpected times. One of the next steps in this endeavor was the creation of regional offices under the motto "Closer to the people" to ensure even more effective contact with citizens in Hungary. I have placed particular emphasis on the establishment of our regional offices because I believe that our main mission is to help as many people as possible. Since I took in office as Ombudsman in Hungary, I have believed that action, personal presence, must constantly complement our human rights messages. Visiting dozens of institutions proves to me that without personal experiences, conversations and encounters, without openness, honesty and trust, the work of human rights defenders cannot be complete. With the utmost care, we looked for opportunities to collect and analyze experiences from Csáford János to Nagybajom. These are two small Hungarian towns. We also ensure even more effective contact with the people through our regional offices in the regional centers. As citizens living in rural areas can now initiate ombudsman proceedings in person at locations close to their homes. I believe that this is a common and important value for our whole society. From 2022, citizens are able to apply in person for an ombudsman procedure in 6 cities in the countryside, in addition to Budapest in Hungary. These 6 cities are Szeged, Debrecen, Győr, Miskolc, Székesfehérvár, and Pécs. The Fundamental Rights Commissioner's Office receives around 8,000 complaints a year in Hungary concerning fundamental rights and those relating to police action, public interest reports, and complaints against their handling, discrimination cases since the 1st of January last year. The Ombudsman inquiries can also be initiated in our regional offices in all types of cases. The Ombudsman procedure is free of charge. The costs of the inquiry are paid in advance by our office and can be carried out by appointment. Our staff can not only help with this, but also provide information and advice on general Ombudsman issues. And now about the Ukrainian conflict, the Ukrainian war, the impact of the Ukrainian refugee crisis on fundamental rights. On the 24th of February 2020, Russia attacked Ukraine, which has a huge impact on fundamental human rights. The war raging in Ukraine right now is traumatic and deeply shocking for everyone in Europe and all over the world. All this, however, should not paralyze us. We should be committed to protection of human rights in this situation as well. We should show active solidarity. We should help and support all the victims of the war, the persons fleeing their country, both individually and as a community. In view of the above, I decided already on 28th of February 2022 to personally provide assistance to people in need from Ukraine together with the staff of my office. 5 assistance points have been designated along the border where refugees can receive all the help they need from both governmental and non-governmental organizations. These 5 points are in Záhony, in Barabás, in Lónya, Beregsurány, and Tiszabecs. You can see on the map. Now about the activities of our office to help people fleeing the war in Ukraine. In order to achieve the objectives already outlined in the introduction, the Office of the Commissioner of Fundamental Rights and the National Human Rights Institution of the United Nations in Hungary opened a temporary field office in Záhony railway station on the 3rd of March, in Beregsurány on the 17th of March, and in the Box Sports Hall, it is in Budapest, on the 29th of March, to provide direct support to people fleeing the war in Ukraine. The staff of my office will assist the victims in the administration of their cases, provide legal advice, provide personal assistance by giving the most important information to refugees, and providing information on how to lodge a complaint concerning fundamental rights, and provide humanitarian assistance as well. Our activities to help the people fleeing from the Ukraine. At the same time, we now have a section on our website, you can see here, where in addition to our community page, we provide regularly updated information in Hungarian, Ukrainian, and English on asylum law for those who have fled the war in Ukraine. We have also organized a fundraising campaign for charities within the office with donations offered by our staff to help people fleeing from Ukraine. And now about the activities of the Office of the Commissioner for Fundamental Rights in the international stage. We are also using our office's international contacts to help people fleeing from the war in Ukraine. In first line, we have issued a joint declaration with the Ombudsman of the Way 4 countries to protect the human rights. We joined the ENOC Joint Declaration on the protection of children's rights. I have engaged in online consultation with partners, ombudsman institutions, and we produce a regularly updated newsletter informing partner institutions about the current situation and our activities. Yes, and because we have no lot of time, yes, on the end, Simone Weil said there is sacred in every person, but it is not in his person, nor yet is it in the human personality. It is this person, no more and no less. The purpose of our activity and our work is to always see the human side of the issues to be resolved and to help create certainty above all legal certainty. Thank you very much for your attention.
Thank you very much indeed for presenting that. Again, under pressure, you did it beautifully. We'll have time for questions. The third speaker is the celebrated colleague from the Netherlands, Reinier van Zouten. You're warmly welcome. You've done a great deal in this area, but that doesn't give you the right to have more than 10 minutes to talk about it.
Thanks so much, Rob, and thank you, Andreas, who just left, for this wonderful conference and these very important topics, and thanks to the colleagues who already gave their 10 minutes talks for what they have brought already to the audience. I will be indeed brief, because what is good comes fast and is brief, and I will refer to things that we already have been doing in the past. Yesterday we signed the memorandum, Rob. So in the memorandum you find already all the details of our discussions we had in Manchester. We wrote a paper for the Manchester conference. You can consult that. There is also, and I think it was in the book you produced actually during your last conference in Israel, the piece Peter Tindall wrote on the IOI sharing best practices and supporting global standards during COVID-19. There also, if you are interested, you find lots of information on vulnerable groups and on what's going on and what role we can play, but it's better to say that we must play in these days. Actually, there is only one message I would like to send to you and give you back home, and it has been said this morning already by Julia Dalvik. They do not know that we exist. They do not know that we exist. And if they do not know where we are. And if they know where we are, they do not know what we do. And if they know what we do, they don't believe us. That's about, and so keep that in mind. We think, and for good reasons, that we are very important institutions, that we're doing lots of good work, and we do. Yes, we do. But there is much more to do than we do at this very moment. And I'm sure in my office, if I do not reach out to others and vulnerable people and groups, we will have plenty of work for those who know how to file a complaint, and for those who know how to speak out loud, and for those who know how to reach us. So this talk, this small talk, this cut the crap talk, I would say, is about those who are never in our offices, who have never been there, and how do we get to them. That is the most important part of what I'm going to tell you now. And actually, it can be said even shorter than in 10 minutes, so I make it a bit longer, what I had to say, that I reach the final 10 minutes. You find in the best practice paper already that there is a significant need to develop strategies for reaching vulnerable communities. This area will benefit greatly through sharing best practices. We are therefore asking colleagues to submit evidence from their own contexts and best practice of reaching marginalized communities to the Netherlands Ombudsman to support the drafting of a best practice. This part will be part of what we are going to do for the preparation for the 2024. We pick it up again, we work on it, we are willing to and hoping for your good and best practices so that we can incorporate them in what is finally, you know, the paper is a paper, but it's important to mark that we as a community are there for those who are vulnerable, and our practices and good practices can be shared, and we will all benefit from that. So, yes, please. It was already, I think, mentioned also in Manchester, we had some research done and investigations, more or less in line also with what Julia told us this morning. That was specifically on the digital and the online and IT part of our work. But we tried to find out, first of all, which target groups do not know how to find the Ombudsman when they need help. Those are the ones who do not know, etc. And the second one is, how can the Ombudsman raise its profile among these groups? So if we know where they are, if we found out where they are, then we have to raise our profiles. What can we do then there? The research showed actually 5 groups that we are now working on to get this profile. Young adults, migrants and refugees, the self-employed small offices, certainly now in the post-COVID-19 times, where small offices and self-employed are having very, very hard times to get their businesses back on order. And they need the support of governments, and so they need also the support of ombudsmen. Single and young parents, and older informal carers and single elderly people. These are 5 important groups we identified on the basis of research carried out by an external organization, not by ourselves. So we are going to work on these 5. What we then discovered, the first thing that we discovered was that it's near impossible to get in contact with all these people. In my country, there's living 17 million, and I have 250 staff. We can't reach everybody, so we won't do that. So we need others in society and NGOs and civil society to help us out and to bring us in contact and tell us what's really going on in society. So we found actually that we must be in contact with the intermediaries, as we call them. Interest groups, general practitioners, psychologists, legal desk, lawyers, those who give advice to people, healthcare NGOs, you name it. There are so many people active in society, professional and also non-professional, and we must know what they know, actually. They know the target group and their problems like no one else. They are often the first point of contact for that target group, and if they do not reach these intermediaries, then there will be no contact whatsoever with any governmental body, leave alone the Ombudsman. And third, this approach saves the target group having to deal with any other public authority. So the intermediaries also helps them avoiding that they have to come in close contact with the governmental agencies, and it helps them enormously. What do we do? And there is lots more to say, but I'll just be brief, bullet pointed. We expanded our website with a dedicated section for these intermediaries. We introduced an advice hotline especially for these intermediaries. We developed an online counseling desk to lower the threshold for contact between these intermediaries and the Ombudsman and its staff. And we made an online counseling desk. And I must admit, at first I thought, this is a bad idea, you know, online, etc., will not work. But we managed to build a digital platform where we have now over 500 intermediaries working for us. We have webinars with them. They have their own informal exchange groups. They know how to find, and we have, of course, this is sort of a manager of this platform that helps them out, and this is a professional that we hired specifically because we do not have the knowledge in-house ourselves. Success, yes, and I'm not going to explore on that some other day, 2024. The company, we hired the same company that did the first research, and we asked them, please, what do they think about us? So we now know how to reach them and how to find them, but if we have found them, how do they think about us? And we approached 3 groups: the receivers, so the vulnerable people themselves and the groups, the intermediaries, and government. And what I ask about, I'm sorry being so brief, but I can send it afterwards, you can read it after. When they expect that the Ombudsman could help, when do you think we can help? Who do you think we can help? And about what topics, what issues the Ombudsman can help? What do you think? And the answer was rather, well, there was two more. How do we remain in touch, in contact, and would you like to cooperate with us? Some of the answers. Most of them did not know what sort of mandate and what fields we have competence, what we do, and the way we work in our practice. I have 3 more minutes and 2 points. So there was no well described idea by those intermediaries who we are, what we do, what we can, although they knew we existed. And there was also some of the people we got in touch with in this second research. They weren't aware of the fact that they also could complain on behalf of some of the people they help. So how to reach our office, they didn't know it. So they were actually as vulnerable as the people they worked for because they didn't know we existed, what we did, and what we mean for them. There was a sort of preconceived idea that the Ombudsman always is a sort of lawyer in service of the citizen, which is not true. We are trying to build bridges between the people and governments. And our communication, there was lack of communication. They told us we were not clear enough in the media, on our website, in our other ways of communicating with them. So there is lots of things to do and to gain and to win. Last minute, quick wins, yes they were. I just read them out loud. Do not use private or general numbers, phone numbers, so that intermediaries seeking help can call back in targeted manner. So, you know, they sort of came into this general numbers approach, and they said, well, you know, we have knowledge, and we would straight and strict and direct contact. So that is what we arranged for them. Second one is create an overview of types of questions about which intermediaries can or cannot contact the Ombudsman. So be clear about what we can do and what we will not and cannot do, so they know where to come when they come to us, what to expect, and have a sort of responsiveness as we are asking from governments. You know, when you phone a government agency, we want them to phone you back within 3 days, and they told us, please, Ombudsman, can you do that yourself also? And so the platform helps. Give the right information, be clear and strict about what you do and what you cannot do, and they are then, in those circumstances, very willing to help you out to reach the goal we set for ourselves, and it is reaching vulnerable people that do not know that we can help them and probably even didn't know that we existed. Thank you so much.
Thank you very much, Renier. Very stimulating and lots to think about. So you've had 3 complementary but different presentations, and now I'll go round and take questions which we'll deal with together. So if you'd like to ask a question or make a point, please indicate, and we'll log that and ask colleagues to respond to it. So who wants to take a golden opportunity to ask the experts about this key question? Right, we've got someone online. Daniel, welcome, Daniel. Good to see you. But we can see you but can't hear you. Okay.
Now it should be fine. Thank you. Good to see you too. And thanks for the opportunity to participate online to the Greek office, which is, that's a great opportunity. I wanted to ask a question to Dr. Akos Kosma from Hungary, and I'm sorry to ask about something you have not touched upon in your presentation, but it is related to reaching certain vulnerable groups. And the question is that we've been hearing in the past years about an increasingly hostile environment towards LGBTI people in Hungary. And in that context, I'm wondering whether you're finding any challenges in reaching out to that particular community, and how do you do that? Thank you.
Thank you, Daniel. That's good. Who wants to go next?
Is it on? Yeah. I just have a comment rather than a question. Another thing that I find very interesting in the context of reaching out to people and informing people about the mandate of the ombuds, I think there is a kind of a dilemma, because on the one hand, I see that ombuds institutions want to reach as many people as possible, but at the same time, they have limited resources of dealing with the complaints, and they are trying to filter out those complaints that are not cannot be treated by them. So on the one hand, institutions want to get as many complaints as possible, so to say, but on the other hand, for example, through online complaint forums, trying to reduce the complaints that they actually have to deal with. So I think it's a bit of a dilemma. And how do you ensure that you don't push off those who might actually have a complaint, but it's filtered out through the online complaint? I think that's a possible problem.
Thank you very much. Who's next? Yeah, sir.
Yes, it's regarding the presentation that the Ombudsman of the Netherlands just made, which was very interesting. But according to my experience, when dealing with NGOs as intermediaries, sometimes you get some, I think in my case, blocked for a kind of lack of confidence, or a kind of some ideologically led NGOs who would like to have a kind of monopoly of the complaint, so they don't help you because they want to keep them, keep the complaint in their field. Is that something that it's happening to you or to other ombudsmen?
Okay, thank you. I'll take one more question and then we'll go to the panel. Anyone want to come in? No? Okay. So, panel, we have 3 questions. I'd like you each to address all 3 questions because I think they're relevant to everyone, not just to individuals. So the first question was directed at you, but I think it applies to everyone. It's about hostile environments created by governments and what impact that has on the Ombudsman in trying to speak truth unto power. So would you like to start off, say something about that?
Okay, I would like to speak Hungarian and my colleague will help to translate my words. Szóval először is megkérdezném a kollega urat, hogy milyen szervezetet képvisel, mielőtt válaszolunk neki, hogy milyen információi vannak Magyarországról.
So before I answer this question, I would like to ask my colleague what information he has available about the situation in this regard in Hungary and what organization he represents here at this conference.
Okay, he's an ombudsman colleague, and we don't have time.
Jó, csak én szeretném tudni, hogy kinek a nevében teszi fel a kérdést.
I just wanted to know on whose behalf he's asking this question. That's all I wanted to know.
Well, I think he's asking it as a fellow ombudsman having to deal with a situation where we have to work with governments. So we don't want to get sidetracked by that.
Ne igazán vezessen félre minket most. Ki kérdez, vagy ki nem kérdez, hanem arról.
Akkor nem kérdezzük meg őt?
Nem, szerintem nem. So shall we not ask him now where he gets this information
We don't have time for that.
Nincs időnk rá, sajnos.
Jó, akkor én is csak egy mondatot szeretnék mondani, ha rövid az időnk. Azt gondolom, hogy olyan információk, amelyeket nem támasztunk alá, nem szeretnék foglalkozni. Hozzám ilyen jellegű felvetések, amiket a kollega úr mondott, nem jutottak el. Azt gondolom, hogy mi intézményünk is mindent megtesz a különböző sérülékeny csoportok érdekeinek a védelmében. Az pedig, hogy a kormánnyal kapcsolatos kritikus hangokat megfogalmaz, azt gondolom, hogy nem a mostani tanácskozásnak a témája.
So I would just like to give a very brief one-sentence response. I wouldn't like to deal with any such information that is not supported by any facts. I do not really want to go into detail here. From my part, what I can say is no such complaints or criticism has reached me in this respect. Our institution is trying to do its best to protect all the vulnerable groups who turn to us. And as regards any ideas criticizing the government, I don't think that this is the forum that we should deal with it at.
Okay, thank you for that. Renier, do you want to say something about this?
Thank you. Thank you, Daniel, for the question. Yes, of course, it's very important that it's not only now we focus on the vulnerable groups, the 5 groups I mentioned. You're fully right. Every day there are people color of their sexuality, other preferences, being a refugee. So yes, it's important, this question, and I'm sure it happens in all the countries of our association, and we have to prepare as almost that. And for example, I can tell you, we have lots of complaints about police behavior. We have lots of complaints about the way people are treated on different public authorities and the way they from time to time just on the streets and where there is no action taken by governments to protect them. So there you see it's a very important question, and the hesitation I have, Daniel, is that I wouldn't like to call them vulnerable in the sense I used for the other 5 groups, but yes, in the essence, from time to time, people that you know are not just like old white 62-year-old Western Europeans. Those people, they need protection, certainly in my country, but I'm sure also in the country or this table, all of them.
Thank you very much. Do you want to add something?
I will refer to the question of our resources that are limited, and still we want to reach out to new complainants. So first of all, I think whenever you allocate researchers, you should be focused. And I believe that one of the idea here is to be focused on the less powerful parts of our communities and to reach out for them. So to focus our efforts in those vulnerable communities and this is one element. The second one is from our experience. We went up from 15,000 complaints 2 years ago to 20,000 complaints, having the same staff, and part of it is also trying to formalize new ways how to deal with complaints, quicker ways to find not only the justified complaint, also to solve the problem. And sometimes by a phone call, especially during the pandemic, we found out that it would be better to have a quicker solution than the right solution. Of course, it should go together, but of course, sometimes you should solve the problem for the complainants as quick as you can do it, and this will assist him a lot. Of course, you can use some other tools, such as mediation, such as other ways to handle in a quicker way some of your complaints. And in a way, and we are, at least in our office, we deal with any complaint. We don't pick up whatever whatever we want. So we try to keep. And another idea is also to try to find out some solution from one complaint or from few complaints that relates to bigger population, to demonstrate and to also to speak to the public body and to recommend him about if you see some. For example, 2 years ago we received many complaints regarding the medical cannabis. Okay, so you understand that the Minister felt the process is not good, something is not good. If you receive, many of us, I think now we spoke about, I think receives complaints about renewing passports in many of our countries. So yes, you can pick from few complaints and have some suggestions to your ministries or Ministry of Interior how to deal with it, and by that referring to bigger and bigger population and to have more influence.
Thank you. So that's emphasizing the strategic elements of dealing with complaints to ensure you meet as many people, reach as many people as possible. So then the last question I want your comments on, please, is your experience of dealing with NGOs as intermediaries. Do you find them wanting to steal the glory, or is it not a problem? Rainier, start.
Yeah, and I like that, actually. And it's depending upon the topic. Working with associations that are supporting refugees, there we are sort of comrades. But from time to time when it comes to discrimination, or we have called Control Alt Delete, is also watching over me, I would say, as a watchdog. So how is the Ombudsman dealing with it? And I can understand that. And if you shouldn't be sort of defense yourself. Try to build a relationship and try to show them that you can be of serious help for those they are also working on. But yes, you're right, from time to time. You know, and there's so much glory for an ombudsman, I can share some of it with another one.
Thank you. Mr. Cosmo, you obviously are working closely on refugee questions. Do you deal with intermediaries when you do that?
Természetesen, tehát mi nagyon sok civil szervezettel dolgozunk együtt. Fordítsuk gyorsan.
Of course, we cooperate with a very high number of civil society organizations.
Több alkalommal évente összehívom azt a tanácsadó testületet, amit egyébként a hivatalomban működtetek.
There is a civil consultative body that I operate in my office, and I convene them several times a year.
És amikor pedig szükséges, nyilván soron kívül is meghallgatom a véleményüket.
And
ez több mint 20 szervezet.
When necessary, I actually listen to their opinions out of order. This actually means more than 20 civil society organizations.
Én azt gondolom, hogy ebben jól állunk, nincs probléma.
I think that we are quite good at this, in this respect, so there are no problems in this field,
Good.
fortunately.
Thank you very much. And to end it,
I would just raise two issues regarding dealing with NGO. First of all, we are objective. So we hear from everybody, we collect complaints from everybody, but we have to be professional and to give the services as we understand and as we know as the law allows us. This is one point. The other point is sometimes we find out that, it was mentioned before during this day, that we don't have authority. For example, in cases of private sector, we can receive complaints, but we cannot deal with them. So for that purpose, we might use those NGO and to let the complaints know, look, you can go to the bar and maybe there are some volunteers over there that can assist you, or some other NGOs. So you can be also very fruitful with the collaboration with NGOs. At the same time, once again, I think it's very important to stay objective, to stay professional, and to act like this.
Okay, thank you very much. Could you please show your appreciation for 3 superb presentations? Thank you very much. We'll take a very short break at this point and then reconvene in 2 minutes for the closing ceremony, led by Ombudsman Patakis, who is going to have the final word. So, thank you.
So, dear colleagues, this is the closing ceremony, and I'm presiding the closing ceremony. There is no closing ceremony, obviously. Many thanks to Rob Behrens for chairing in such a fascinating manner the last session, which was it was bound to be a difficult one after lunch. We were expecting good weather. We didn't expect that the weather would be so kind to us, perhaps too kind to be having a meeting indoors. And perhaps next time we should make necessary arrangements to have some of our sessions, at least, those closer to sort of lunchtime, outdoors, especially as we are nearing the beginning of the summer. And for those of us who are living in the Mediterranean basin are aware that it can get really warm. Many thanks to all the contributors, all the colleagues, all the associates, and everyone who made the effort to come to the General Assembly meeting of the European branch of the IOI, and also bearing with us today at such a hot day. I hope we all learned a few more things, or at least there was a lot of food for more thought coming out of the discussions and the presentations that we enjoyed today. I have to thank, of course, our interpreters, and may I ask for a round of applause. We truly appreciate your effort. We hope that we did not torture you a lot. I understand that having to work in this booth can be really, really torture. Many thanks to, I have to say many thanks to our IT team for making all the necessary arrangements for the mics and for the video and the cameras, and for the online participation of all our colleagues who could not make it to Greece this time. And may I also ask for a very warm round of applause to the team that organized and also made all the necessary arrangements for all our stay to be as comfortable as possible. Alexandra, Gianni, Christina, the entire team. I'm sorry if I have forgotten someone, but many thanks. Truly, we do appreciate all your efforts. I hope we did a good job. If not, we hope that you will give us a second chance at some point, and we will make it up to you. So, dear colleagues, it has been a great privilege, truly, to be with you after such a long time in person. I think we probably, it has been a long time indeed. We kind of missed each other. I think the last couple of days were clearly demonstrated that, technology may be advancing, but the human sort of presence and the human interaction cannot easily be substituted by any technological advance. I think that we had the opportunity not only during the sessions, but also, and perhaps more so, in between sessions, to discuss and to catch up with our news and where we stand as offices and what our new challenges are. I'm grateful to all of you for making the effort to come to Greece, and I wish you all a very pleasant and safe trip back home. Thank you very much. I would have raised my glass, but I only have a coffee cup, so here's to you.